of the document item 17 and 18
These are old matters.
dotlet. Difficulty not we are asked to obtain the instructions dotlet. Those have not yet been distributed. Come up after dot
So we have seen your memo, but 17 matters.
Dot.
How much time? How much time?
Next week also in my case also, there is no record is required. My project is very limited part. On
So
the
how much time will you require to have the abstract?
next week also,
17 matter, we'll fix a date then. A prayer for adjournment has been made by MDV. Council appearing for the Dibrugarh University. So, para, considering that this case is of the year, these cases are of the year 2017, that the matter, a short adjournment is granted by directing listing of the matter on, we have it on 13th of June. 13th June, enough time you have.
public.
Take what to
Maybe. But to admission matters, year 2021. Hey, report.
next report, so we have picked many cases. Matters of which year 21.
21.
Okay, right. On 9th.
You can similar prayer logic for listing in next week was
Next we have what matters of which year
22.
you give date there on the next week. Give it give 14th 14 June.
Public. Item 13.
1-3.
One, I am appearing on behalf of respondent number 5. I have 3 time file affidavit proposed.
Inform the other side.
Lord.
What is your name?
P. Gohai.
P. Gohai. On the prayer of Sri P. Gohai. On of P. Gohai, let it counsel for respondent number 5. Matters been returned by 3 to enable filing of counter affidavit. Yes. Is there any interim order, Mr. Gohai?
Matter was might not be here, it was completed. It was reserved for judgment. For necessary orders, the judgment is released and is lying in the bench. So this matter can be dismissed.
Pertaining to this bench?
No, my lord. The court number
No, it's okay. We are not bothered about it. Is it a bench to matter?
bench to matter. But
Matter which
I think bench to matter only one bench is sitting this.
no, the there is another
Court number 4 is not sitting. Court number 4 not sitting.
Fine.
Wherever it is, it may be listed.
of which year? Case of which year?
Last year, but hearing was completed.
23,
24,
22.
hearing was completed. Order says,
You have it on 12th of June, Monday.
I think it would be better that
We don't know. We have not heard the matter. 12th of June.
Yes,
Give the date 12th June.
So the
Ask some of your question. It is the who is it?
to consider the other side. I have to mention item number 10 here.
10. Yes.
Senior is out of senior.
The senior is P. Mohanta.
PK open here.
So you are for the respondent.
Yes, sir.
Guwahati University.
Yes.
And from the other side.
I'm from
How much time? 2 weeks?
10 to 6 on 12.
A prayer for adjournment has been made on behalf of the chief understanding of Guwahati University. Please, matter according to change adjourned, it is on 12th of June. Madam, is there any interim order?
No.
No interim. No interim order.
mention one item for this. Was supposed to be for
matter? Matter of which year?
Matter of there is
22.
urgency.
22. Urgency in the sense what is it?
Urgency for the petitioner sit for exam. He is not in doubt. He is in bar sit for exam.
When are the exam scheduled?
Exam scheduled on June last.
We'll have it on 12th of June. No, not on 12th. We'll have it on 9th of June. Exam. Yes.
Like
May it please, my lord. My lord, may I pray for a listing of a matter pertaining to the year 2022? The matter relates to the discontinuation of the service of Tiva language teachers. I am appearing for Tiva Autonomous Council, my lord. Since the pleadings are complete, my lord, may list it for admission.
Is there any interim order?
No, my
What is the urgency?
my lord.
We'll have it on 14th. 14th June.
14, my lord. Okay.
Thursday. Thursday is not a matter for orders. Contempt is not urgent. When was it last listed? 22. 23. What is the urgency?
They are getting, they are waiting to get.
No, we'll not allow. Contempt is not urgent. 18 it was listed. No, not like that. Yes, next.
May I please, Your Lordship, item number 21 adjourned for 2 weeks, Lordship.
You're for whom?
And for the
Petitioner. I is by the petitioner itself.
Lord-
I is for what?
I withdraw, Lordship. I have for withdrawal, but some changes the circumstances. We need instruction from the petitioner, Lordship. That's why we want to time for 2 weeks, Lordship.
I to withdrawal account. No. I 2504. Item 21. I is for withdrawing the petition.
Yes, Lordship.
Then why do you want instruction? In a matter of fact, in the public. For this is pending since 2022. Why do you need time? Petition is itself of 2018.
Lordship,
We're not going to adjourn a petition of 22 for withdrawal.
Lordship can call my senior.
Ask your senior to be here.
I am for the petitioner, my lord. They have filed an idea for withdrawal, my lord. So I have also some instruction. I have no instruction to withdraw.
You're for whom?
I am for the petitioner. He is the original. I am for response number 7, lord.
How can they be two? One council will address for the petitioner. Who will address? You decide among yourself. We don't mind you addressing or her addressing.
Lordship, the petitioner lastly engage our.
Yes, you have filed the
seniors,
application for withdrawal. We'll pass orders.
Lordship, kindly adjourn for today, Lordship.
We're not adjourning a matter of 22 for which has been filed for withdrawal, madam.
You can call that call. I will senior.
When the matter reaches, ask the senior to be here. We'll pass orders. And we have recorded in the last order that you are already appointed as in charge principal in the meantime during dependency.
I have no exact instruction, Lordship. My senior will appear and he will better explain you, Lordship.
Last time we have Mr. Laskar had appeared and said that he had not filed the withdrawal. It has been done by somebody else. But the petitioner has been appointed as in charge principal during dependency of the
Appearing on behalf of Mr. Shaharia, Lordship.
Understood. But we'll take up the matter.
This petition, my lord, in the challenges, my lord, regular headmaster. But he is now appointed as in charge, my lord. So in that respect, I have no instruction.
Be here when the matter is called upon.
May please, Lordship, I have to mention for listing, Lordship. Lordship, mathematics next week, any date, Lordship.
Matter which year?
2022 Lordship. Lordship provincial is no service.
Not next week.
Next week. Oblige,
Not next week. Have it on 16th of June.
oblige, Lordship.
May please, Lordship. Okay, item number 5 and 6. In item number 5, I have filed a affidavit, Lordship. Lordship, that may be called for, Lordship.
Give a requisition.
May I please, Lordship? I beg to mention WBC number 5963 2022. It was last issued on the month of September 2022. Lordship, may kindly fix the next week.
On 14th June.
Deep
May I please, Lordship, prayer for listing on WPC 1573/23, Lordship. Matter relates to regular payment of salary, Lordship.
23.
Yes, Lordship. The petitioner is getting fixed salary instead of regular salary.
You want scale payment.
Yes, Lordship.
When was it last listed?
Last is the 2003, 10th March, Lordship.
There's no urgency as such.
Yes, Lordship. So,
Don't
matter-
mention it now.
Lordship,
Don't mention it. We are not allowing this.
that's the next week, any day, Lordship.
Not an urgent matter to be listed out of turn. Yes, next.
May I please, Your Lordship, I beg to mention WPC 2847 of 2019. As per last order, the matter was to be fixed on 29th. That is next
19
week.
matter is when do you want? When do you want?
Lordship, tomorrow or day.
Not tomorrow. Tomorrow is not possible. Have it on have it on 5th on 7th of June. 7th June.
Lordship, item number 3, the daily list. I pray with your Lordship to kindly allow me to withdraw the petition, Lordship.
You're on record.
For the petitioner A Rekha.
A Rekha.
Yes.
After A Rekha, Learned Counsel for the petitioners submit that there is instructions from the client not to pursue this petition. Full stop. Sarah also heard higher education. Also heard MS Sri Das Burman, the State Council, as well as Sri Das Learned Standing Council Higher Education. Full stop, Sarah. Petition accordingly stands dismissed on withdrawal. Yes. Is there any interim order, Mr. Rekha? No.
No,
May please, Your Lordship. I pray for listing of a matter for admission. Lordship, the matter pertains to the post of headmaster in charge, which the petitioner is being deprived of holding.
Which year?
Lordship, this is a 2023 matter, but Lordship, the petitioner is due to retire on this year. So Lordship, the matter may kindly be,
When is he going to retire?
Lordship, on December.
No urgent. Sorry. Next.
Your Lordship, I beg to mention one item, mention one case for withdrawal. Writ petition 5757/2020.
Okay. We'll have it on Friday. Today is what? Tuesday. We'll have it day after tomorrow.
Day after.
Yes.
Obliged.
May I please, Your Lordship? Lordship, in this matter, my lord, on last occasion, court has directed us to produce the record, my lord. Here, the record has been sent by the office on 18/8/6/2018. So this was the earlier set of council. They have received the record, but thereafter we have not received it, and moreover, we have not traced out the record in our chamber, man.
Lordship, in fact, Your Lordship, from last occasion, Your Lordship, when the matter was supposed to be order was passed in this matter, Your Lordship. Record was with the, probably as far as I can remember, Your Lordship, with the Honorable Court.
Can you reconstruct the record? Sharma,
My lord,
can you reconstruct the record?
I have to ask the
Have
department.
you sent an intimation? Have you communicated to the department?
Yes, my lord.
When?
My lord, we have communicated through the order, my lord, and they searched it, and they thereafter give us this letter, and they have stated here that they have submitted the original record.
That we have understood. That is
Yes.
that is not the solution.
Yes.
The records are not traceable. You have to do something. We cannot. Case will not wait for the record
Yes, ma'am.
till indefinite time. We give you a chance to reconstruct the record, whatever is there. And if you by the next date you can produce, you produce. Otherwise, it is a matter of 17. Doesn't look good that.
Yes.
And in the last order, we had made it very clear that we had recorded the background also.
Probably your lordship in the office of the inspector.
You try to whatever copies are there.
Office will be there.
Try to reconstruct the record.
Well,
We'll grant you some reasonable time.
Yes.
Records will come from which place?
Jorhat.
Jorhat.
But the selection records will be in the directorate.
Directorate.
School selection committee has sent a record.
No, there may
They are
be a necessity to communicate with Jorhat also. If the directed records are not there, we will grant some time.
And one more thing, Lordship, in all the other departments, Lordship, the STR and integrity mark is given to the candidates. Only in the education department, it is not provided to the candidates. So if they can provide the STR and marks,
The gradings are required to be communicated. That
Always.
is the part. That is the requirement of law. Why is the education department digressing from the normal practice? May not be connected only to this case. This is a general proposition.
Yes.
Not only communicated, they have to be given a chance if they want to represent against such gradings. Though this matter was was directed to be listed today by the last order dated 23/5/2023, it transpires from the submission made by the Learned Counsel for the parties that the original records of the case was misplaced. Records were misplaced during the present proceeding. Considering the said aspect, misplaced in the court, in the course of the proceeding. Considering the aforesaid aspect, and also the fact that the Office of the Inspector of School, Jorhat, is involved, this court deems fit to grant a further opportunity to the Learned Counsel for the Education Department to reconstruct the record by obtaining copies from the concerned offices through the Director of Secondary Education, Assam. Therefore, in the interest of justice, matters can be adjourned by 3 weeks to enable the Learned Counsel to do the needful. Full stop. Place the matter on on 27th of June 2023, on which date, no further adjournment, no further prayer for adjournment would be considered.
can it be reckoned 22nd, because record is available of the school selection. They are
No, we have intentionally have given enough time because we are not granting any adjournment. 27th and Tuesday we have fixed intentionally. We'll go for our disposal.
available.
Lordship, in this matter, Lordship, we are supposed to file an affidavit, my lord. We'll be filing, my lord, we got this thing.
You got the instructions or not?
My lord, no, my lord, because the order was not online.
Oh, as will done sometime. Three A. Fukan, done at Standing Council, Elementary Education Department submit that due to some technical issues, copy of the order dated 25/1/2023 was not readily available. He accordingly prays for and is granted 3 weeks time to obtain the instructions as file at the end of court. List of the 3 weeks. 3 weeks. Upon the same date,
Hello.
the directions contained in the earlier order regarding apprising this court of the marks of the petitioner for her NCC certificate as well as cultural activities may also be obtained.
We'll do that.
You have a last copy order. You've seen that last part. there
Yes,
is
sir.
some
I just checked it up.
last line order, but last line. Should also be complied with last. May also be complied with. Yes.
Deeply obliged.
May it please your lordship. And of your lordship, kindly, my lord, in this case, there are several orders passed by this honorable court. There is a direction from
Oh, that.
regarding
college,
my lord, college.
Okay.
Your
We
lordship,
hear this. We hear this. We hear this. Yes.
my lord, that college, my lord, that's Kamalakanta Besgura Memorial College Research Education. And my lord, that college was established in the year 1990. And everything has been fulfilled, my lord, and college was running very smoothly, nothing there is a affiliation.
1990.
1990.
1990 it was established.
Yes.
Okay.
So all formalities is over, my lord, and everything has been done. And what happened, my lord? There is a focus notice was issued to us, my lord.
Hmm.
That is Annex 4, my lord.
Date.
Page 26, my lord.
Date.
That is my 25, 2015.
28th of May.
Sorry, my lord, that is the, sorry, that is Annex 4 is the affiliation, my lord. Because under in 2014, my lord, there's a new law, new regulation come, which is create course, my lord. All the BT colleges are under that act, my lord. Regulation.
When was it recognized?
My lord, no, recognizing, my lord, it is 2019, 990, that was recognized. My lord, there is a new act,
Came in 2014.
14, my lord.
Okay. Thereafter.
Thereafter, my lord, everything is going on, my lord, very smoothly, my lord. By Annex 6, my lord, page 30.
Yes.
There is focus notice was issued.
Dated.
Dated 14 to 2019.
14. 19. Focus notice.
My lord.
Page 30.
Page 30, my lord.
Okay.
In various policies there, my lord. And my college is also, my lord. Use the figure there, my lord.
Serial number?
Serial number, my lord, that is not serial number. In second page, my lord, page 31.
There is serial number 2266 point something.
26614.
123.
266 1423.
266
That is
14.
Kamala Kanta Bezura Madam.
Understood.
So we have given reply.
Yeah. 266.14.13. And let us see the contents of this show cause notice.
My lord.
Please read.
I'll read the para 2, my lord, is a 11 para.
No, read the first.
Yes, ma'am. Whereas the institution was granted recognition and conducting research education program as one of the 1 year duration mentioned against 2020 in the basis of the impugn and NCT regulation 2014. Revised recognized order issued in 31st May 2015 from the academic session of 2015-2016 to which institution mentioned below, subject to the fulfillment of condition in respect of the enhancement, additional built-up area, additional infrastructure, additional fund, additional staff, additional fund, additional staff, maintain, update website and comply with the same to the ERC. Para 2, and whereas the State Regional Committee on 266 meeting held on 31st January 2019 considered the aforesaid matter to observe that the following institutions which have not furnished the compliance report according the above order issued focus notice under section 17(1) of the NICT Act and CTE Act 1993, which directed to comply the point mentioned below in 21 days from the date of issue of the letter, taking appropriate decision by the ERC there. A approved faculty list current by the concerned affiliated body along with the requisite document. B approved building plan by a concerned competent gov engineer oblique authority. C approved building compliance certificate by the concerned competent government engineering authority. FDR towards enrollment fund is reserved and after conversion into joint operation mode as prescribed in the NCT regulation 2014. So these are the 4 things they are required initially.
In fact, this was not a so-called notice. This was a notice for compliance with certain formalities.
Accordingly, my lord, Annexer 7, my lord.
Yes.
Page 32, your lordship kindly see. Page 32, my lord.
32.
Page 32. As subject cited above, I would like to inform you that the following particulars are sending herewith as desired by you. It is for your kind information and necessary action.
This is 26/8.
My lord, 26/8/2019, approved faculty list, approved building plan, approved building completion certificate, FDR, web update report, website update report.
Okay.
Then, my lord, again, my lord, they have issued a show cause notice.
14/5.
14/5 and annexed page 32. Now, my lord, they come down to now 2 points. There is specific notice to my college, my lord, show cause notice. Where is the Kamala Kanta Bezgura Memorial College of Research Education College for Taradam Johan Assam was granted recognition for order that is for 100 from the academic section 2005-2006. And where is the basis of the implementation of the fulfillment of the condition in respect of this enhanced additional building up area, additional infrastructure, additional fund, additional staff maintained in the update institutional website and to comply with the same in the years. And whereas the ERC in the 271st meeting held on 25th April 2019, after considering and examining the application along with the document submitted to the institution agenda, note NCT Act and CTR Regulation 2014, including norms and standard guided and issued from the study has from time to time reply in and recognize under the describe the matter in the details. Now come down to 2, my lord, approved faculty is not submitted as per prescribed norm NCT
Yes.
2. Building plan and building completion certificate is not approved by competent building engineer. In view of the above, the competent committee decided and as under final show cause notice under section 17(1) notice NCTE Act 1993 be issued to institution for completion in form of the so and so and so. And whereas and whereas the committee in your opinion that the institution prima facie does not fulfill the requirement and norms and standard laid down by the NCT, accordingly it is provision of the NCT has detailed above. So in that reply, my lord, again, my lord, page 34, your lordship kindly. Page 34, my lord. As the subject cited above, I would like to inform you that the following particulars are sending herewith as desired by you, which is for your kind information and necessary action with regard approved faculty list, building plan approved by the government engineer. So that I have annexed, my lord. Everything is there. Then, my lord, your lordship kindly see page 36, my lord, annex 10, my lord. By the order dated 28/8/2019, my lord, our, my lord, recognition has been withdrawn, my lord. Page 36, my lord.
28/8.
Yes, 28/8/2019.
What happened?
That your lordship kindly see large para 3, my lord. First show cause notice that is the final show cause notice that is institution is still deficient in following ground. Again, 4, my lord. Approved faculty is not submitted as per prescribed norm. Building plan is not eligible. Building completion certificate is not in accordance with the NCT prescribed format. The validity of the FDR expired. In view of the above, the committee decided under recognition granted B.Ed course in without withdrawn under section 17 of the NCT Act for academic session 2020-21. Now, therefore, the recognition granted to the institution by Kamala Besbora Memorial College, Research Education College, B.Ed course is hereby withdrawn under section 17(1) of the NCT Act 1993 with the effect from the academic session 2020-2021.
There is a provision for appeal.
Then I file appeal, my lord. Then everything, my lord, again I send, my lord, because these are annex 11 is, my lord, faculty list, my lord. And, my lord.
Where is your appeal?
My lord, we filed through online, my lord, we have filed it, my lord.
Okay.
Paragraph 16 of the writ petition, my lord, we are mentioned, my lord, when appeal was filed. Paragraph 16 of the writ petition, my lord.
Paragraph 15.
Paragraph 16 of the writ petition, 1/6.
Yes.
The petitioner Baker stated again decision of the the petitioner college submitted appeal on 17/9 for the online following
17/9.
17/9/2019.
Okay. What
So,
had happened?
along with the appeal also I have annexed everything again.
No, that is okay. What had happened? Outcome
Then,
of the
my
appeal?
lord. So we have given the online application also, hard copy also, my lord. We also represent our case also. Annex of 14, my lord. Page 48, my lord. Page 48, my lord, annex of 14. I inviting reference to the cited above, I have the honor to inform you that I am sending here with the hard copy of the appeal from along with the necessary relevant document. This is for your kind information and necessary action plan. Then, my lord, page 52, my lord.
Yes. 52.
We have submitted our written version, my lord. We appeared and we have everything we have been, my lord, we have, my lord. And very interestingly, my lord, FDR portion, my lord.
Yes.
Clause 4.
Yes.
FDR fund comprising rupees 5 lakhs and rupees 7 lakhs, rupees 12 lakhs, granted,
Generated.
generated 8 August 2019 and same is sent to the ERC Bhubaneswar for necessary action on 4/9/2019. There is no lapse of the FDR, my lord. Sir, presently we are providing all supporting documentary evidence in original for your kind consideration and necessary action. Then, my lord, this is the order passed on 16, my lord. This is impugn order, page 53, my lord.
512.
5/12/2019. Whereas this appeal of Kamala Besborua Memorial College of Teachers Education, Buhotia Gaon, West Johat Circle, Johat, Assam, dated 17/9/2019, is against the order dated 7/7/2019, dated 28/8/2019 for the Eastern Region Committee withdrawn recognition for the conducting B.Ed course on the ground that the first focus notice under section 17 issued on 14/2/2019, following the final focus notice dated 14/5/2019. The institution is still deficit on the following ground. Approved faculty list is not submitted as per prescribed norm of NCT building and plan not eligible, but built up area does not clearly indicate building comprise certificate is not a accordance with the NCT prescribed format. The validity of the FDR expired. In view of the above, the committee decided and as under recognition granted and B.Ed course is written under section 17 of the Indian Act 1993 over academic session 2020-2021. And whereas such Lambodor Soikia Principal Kamala Besborua Memorial College of Teachers Education, Buhotia Gaon, West Johat Circle, Johat, Assam, presented the case on the case of the appellant institution on 21/11/2019. In the appeal, the appellant, without submitting any explanation, has enclosed a copy of the building completion certificate. And whereas the committee noted for the file of the ERC that appellant on the basis of the minute on 22/7/4 meeting held on 13/16 July 2019, which is a decision taken without recognition of B.Ed course, the order of withdrawal having been issued on 28/8/2019.
What is ERC?
Eastern Regional Committee.
Eastern Regional Committee.
There are 4 regional committees.
Which was received on 10/9/2019. After the issue of the order of withdrawal, with that letter, the appeal under section 1 of faculty list consists of principal, 7 full-time assistant professor and 2 part-time assistant professor for performing arts and physical education, countersigned by the registered Dibrugarh University on 21/8/2019. Eligible building plan approved by the government engineers. 3, a building comprising certificate issued by the executive engineer, and 2 FDR of rupees 5 lakhs and rupees 7 lakhs jointly taken.
Mr. Mohan, just a minute. Just a minute. Time without recognition, calculation.
My lord, page 54, my lord.
Yes.
So what are the documents they have received, my lord? They acknowledge, my lord. And regarding FDR, my lord, 2 FDR rupees 5 lakhs and rupees 7 lakhs.
No, you come to the at page 54. Second paragraph.
Yes,
which is
the now confined to them, my lord.
Yes.
Whereas the committee noted from the document submitted to the ERC that staff of profile has not been signed by a register on every page, but has been signed only on the last page. And out of total built up area, 2684.225 square feet only, only 9806.2 square feet in having RCC proofing, rest having only CIC proofing. According to the provision of clause 8.7 of the NCT regulation 2014, no temporary structure or asbestos roofing shall be allowed in institution, even if it is the addition to the prescribed built up area. If CIC roofing is excluded, the built up area of RCC roofing available is not adequate for B.Ed course as per NCT norm, which should be 1500 square meter. So now that confined to only that, my lord, your lordship kindly see that 87. 87, my lord. What 87 says, my lord?
No, even
No, that, my lord, now later on, my lord, they have not hesitated that we have rectified it. That is not an issue now, my lord. So that also admitted in the affidavit. Only 87, my lord. Now your lordship kindly see 87.
1 second. Yes.
Now, my lord, your lordship kindly came to the page number 22.
22.
Page 20.
Yes.
The first floor, second floor, and third floor.
Hmm.
Your lordship kindly see there are 3 floors. So by adding this to all 3 floors, it will, my lord, more than 1500 square feet. So their norms is fulfilled. Now, my lord, question arises.
1 second. More than
It is, my lord, total built up area, my lord, 16,008. Norms is 1500 square feet.
square meter.
Square meter. So now it is, my lord, if this all that 3 floors, my lord, that will be above
1600.
1600 square meter. So now, my lord, what happened? Just because this is a permanent building, the rooftop is, my lord, third floor is, my lord, tin, my lord. That's why they is not taken up as a permanent building, and that's why, my lord, we have not fulfilled 87. So now what 87 says, your lordship kindly see. This is the rule, my lord.
We were given a copy earlier.
So probably it is annexed in the their affidavit.
Is it annexed?
Annexed in our affidavit.
Then okay, we will have it. Don't do it.
Your lordship kindly took up their affidavit, my lord.
8.
Page 14, my lord. Affidavit filed by the
And what is the provision? 87.
87, my lord. Page 7, my lord. Page 14, my lord.
Just a minute.
Page 14 of the affidavit. No, I think your lordship can take a picture, my lord.
No, we will have it. Of the affidavit.
My lord. Page 14,
Affidavit by 2, 3, and 4.
my lord.
Yes, yes.
Clause 8, my lord, condition for grant of recognition. Then your stateway, your lordship goes to, my lord, 87, page 14, my lord. At the time of, your lordship got it?
Yes, yes.
As at the time of inspection, the building of the institution shall be completed in form of permanent structure and on land prescribed possessed by the institution,
Equipped.
equipped with all necessary amenities, fulfill all such requirements as prescribed in a norms and standard. The applicant institution shall produce the original completion certificate issued by the competent authority, approved building plan to prove the completion of building and built up area under the document to the visiting team for the verification. No temporary structure or asbestos roofing shall be allowed in the institution, even if it is addition to the prescribed built-up area. So now, no temporary structure. So it is a complete totally. Is it our building is temporary, my lord? So definitely our building is not a temporary building, my lord. So wrongly interpreting this, my lord. In Assam, my lord, even in a 5-story building, top floor is always by the rooftop because of the weather condition in Northeast, my lord. But that does not mean the entire building is, my lord, not permanent building, my lord.
Asbestos will not come into the picture. You have not used asbestos.
Yeah, I am not using asbestos, my lord.
So the
No, even is, my lord. That is in case of temporary, my lord.
that is it. No, the expression used is or
My lord.
or it is either or. That means asbestos is out of question.
My lord.
So you have to. The only reason applicable is temporary structure.
My lord.
You want to contend that it cannot be considered as a temporary
Temporary, my
structure.
lord. So they wrongly.
Only because you have a CI sheet, it will not make it a temporary structure.
My lord. Now I'll come to that, my lord. Then, my lord, this honorable court, my lord, various order passed. See that, then your lordship kindly see the order passed by this honorable court on 25/5/2022.
25,
5/2022.
22.
My lord.
Yes.
Before that, there are various orders, and they asked them to, my lord, incorporate it, my lord, they rectify it, but they have not done it.
Okay.
Then on 25/5/2022,
In this proceeding.
yes, my lord, this lead petition, my lord. A continuous issue had arisen. Has your lordship got it?
25/5. Yes.
A
Contentious.
issue had arisen in this lead petition that the authorities in ERC and CTE has already repeatedly taken a view that any structure whatsoever it is has tinted roof or asbestos roof, the same would be classified to be a temporary structure, and taking such view, appropriate recognitions are not given to the institution house such structure having a tin roof. This issue repeatedly came out before this court, and there are several earlier orders clarifying the aspect and required the authority in ERC and CTE to apply their mind and take a reason view, taking note of the geographical location as well as historical and other climatic requirement, etc., prevailing in the state of Assam. In spite of it, the necessary rectifications are not done, compelling this court to have a personal appearance of the regional director ERC, namely Mr. N.K. Sharma. Mr. N.K. Sharma, on his personal appearance before this court, make a statement that he has realized as the nature of the structure prevailing in the state of Assam and of what manner they can be classified. Having realized that an aspect that Mr. Sharma issued that the court that the necessary rectification will be incorporated. We again clarify that by this order, we are not trying to impress upon the authorities in ERC and CTR that every structure having a tin roof would also be permanent structure, and that will depend on the facts and circumstances of every case. But at the same time, decision would also be required to take as the whether or otherwise the structure appear to be a permanent temporary as per the wisdom of the authorities. Mr. Sharma, learned counsel, assured that a necessary rectification order would be passed and the matter would be placed before the next meeting ERC. In view of this such settlement, it is listed after 6 weeks. The personal appearance of the regional director ERC and CTE stand dispensed with. So after that, my lord, he went back, and my lord, very interestingly, he has been transferred immediately, and they have meeting held. They have stand in the same position. But very interestingly, my lord, your lordship kindly see, your lordship take up my affidavit. Affidavit in reply, my lord. My affidavit in reply, that is that dated 21/10/2022. Have you got it, my lord? That
28 one, yes.
my lord.
Yes.
Dated 21/10/2022.
Yes, yes.
My lord, para 25 is the order, 25 order.
Page.
That then, my lord, your lordship kindly see what they are minutes of the meeting, my lord. Page 35. Page 35. Last para, my lord. CL number 45.
Page 35.
Page 30. Of that of it.
There's no 35.
Sorry, my lord, page 14, my lord, total, because nowadays, my lord, there is running page, my lord. Probably page
Running
30.
page is also not 35. You say your internal page.
Internal
14.
page is, my lord, 14.
Okay, we'll have. This is running page is 84. Running page is 84. That's the same.
Sorry, my lord, this is the affidavit filed by the, my lord, regional director.
Dated?
Dated, my lord, yeah, dated, my lord.
Oh, same earlier affidavit.
No, my lord, dated 21/10, there is additional affidavit they have filed, my lord. Annexing that document, my lord, regarding the EAC meeting, my lord.
By whom?
By my lord, Ravindra Singh.
Ravindra Singh, right. 21/10. 2022.
Yes, sir. That running page 19, my lord.
Sorry, it is not internal affidavit.
They have annexed the code order also.
21/10. 22. Yes. It's 135. Yes. 135 is start. Yes. Which page? Internal page.
Internal page 19, my lord. Page 24, sorry, internal page 8 is the, my lord, court order. Then, my lord, your running page 30, running page, my internal page 19, running page 35.
Yes. Serial 45.
So, CL 45.
Yes, please.
Kamala Base Borua, B.Ed
Okay.
Memorial College of Teachers Education, College for Taran Jorhat. It is the minutes of the meeting of 309th meeting, my lord. The, right hand column, my lord.
Yes.
In the light of order dated 25/5/2022, passed by the Honorable High Court of Guwahati, then WPC number so and so, the original file of the institution along with the other relevant document NCT Act 1993 regulation and guideline issued by the NCT from time to time were carefully perused, carefully considered by ERC on 306 meeting, and the committee made following observation. The clause 87 of NCT regulation 20414 clearly mentioned that no temporary structure or asbestos roof shall be allowed in the institution, even if it is the addition to the prescribed built-up area. The matter was examined by ERC in detail. The committee was of the opinion that the temporary oblique roofing of the institution, which is made by CIC, cannot be considered as a permanent structure in the light of the NCT regulation 2014. It appeared temporary structure which cannot be considered in light of NCT regulation 2014. Then the matter was further heard by the so that is then defined. So, my lord, now, my lord, again, my lord, they have said, yes, we cannot take it, my lord. But very interestingly, very.
What is this reference to the Calcutta High Court?
No, my lord, it's a Guwahati High Court. It's a typographical mistake. Yeah, it's a continuation. Order is continuing.
Oh, is continuing.
Continue, my lord.
Yes, my lord. Oh, yes, oh, the matter was, my lord, that's why I'm submitting, my lord. Why there, my lord? On that decision was taken on what, my lord? That decision was taken, my lord. That meeting was held on 15 September 2022 meeting was held. But the committee does not even know that section is already amended prior to the meeting, my lord. So your lordship kindly see then how they, my lord, they have minutely, my lord, they applied their mind, my lord. This is the amendment, my lord, and more particularly 8.7, my lord. This is your lordship, kindly page 7, my lord. Page 7, clause 7.
4 May.
My lord, this is 4th May.
Hmm.
Prior to that meeting, my lord.
Which meeting?
Where they have taken decision again, this, my lord. Page 35.
What is the date?
Date, my lord, that is
14
in
and 15 September.
September, my lord. And that is the amendment was done in 4th May 2022. It was notified in the Gazette, my lord. But that
What was the amendment?
amendment existing clause 8.7,
Where? Yes.
page 7, your lordship.
Mhm.
Page 7, my lord.
Mm.
I have highlighted that
Yes.
7, my lord, clause 7.
Yes. Yes. Mhm. Yes, please read.
Very last line, my lord.
Yes.
Temporary structure shall not be allowed in institution, even if it is addition to the prescribed filter area. There is no space for, there is no team mentioned now, my lord. That is already amended. So now, my lord, my submission before your lordship, in spite of repeated, my lord, the order passed by this honorable court, they were asked to take decision. And they have, my lord, meeting was held. In that meeting, my lord, they have stated that minutely they have considered all documents. Even their own, my lord, own amendment was not taken place in that meeting, my lord.
Oh, just a minute. Just a minute.
No, more quantification. That is in respect of the principal regulation in regulation 8.
No, no, that is-
my lord.
Just for a moment, my lord,
welcome
in continuation with my senior, my lord, your lordship may kindly peruse that order also, that minutes of meeting, complete, my lord. And we have taken care of this also, amendment portion.
Which minor? We'll see. Yes. Yes. Thereafter, what happened? Committee considered to revise.
So now, my lord,
Yes, at that time, inspection shall be complete information.
very last line, my lord.
Yes.
The committee reconsidered the matter in light of the above provision of the decided in under the matter was deliberated by the ERC the details, and committee was in the opinion that the structure oblique roofing of the institution which is made up by CIC, but in original act there is no provision for CIC, man. CIC the word is not there even. CIC is temporary structure and cannot be considered as a permanent, which cannot be considered in light of NCT amended regulation to the yes, my lord. They have considered it, my lord. Now they have incorporated a new word, my lord. CIC. In the original regulation, there is no CIC also. Now, my submission before your lordship,
Findings at page 30, 155. Findings. After working. Yes.
so now, my lord, your lordship kindly see, they stand that because your lordship, my lord, already picture I have my college, my lord, I have shown to your lordship. And if this building is going to, my lord, term as a temporary building, temporary structure, then my lord, it is absolutely, my lord, uncalled for, my lord. Because your lordship kindly see, then my lord, our civilizations, Bangladesh, Cotton College, they are temporary building. According to their regulation, according to them, my lord. That's why, my lord, repeatedly, my lord, they are order passed by the assembly, take a decision, you take a decision, you take a decision. Even in now, my lord, as amendment, KICD is not there, even then they have to take the temple. They stand by the temple.
So initially, there were use of expressions tinned and asbestos.
My lord,
Amendment took deleted those portions.
my lord.
Amendment stated that it should be a permanent structure. And there was a direction of this court on 38/2022 that you reconsider under the amended provision,
My lord.
where asbestos and tinned has been left out.
Left.
And only the consideration has to be on the part of temporary structure. They have said that this particular building, since it has TI seats, it is temporary in nature.
Sir,
Yes.
so, my lord, your lordship kindly see if it is, if they, my lord, according to them, if it is a temporary building, my lord, then I have nothing to say because what I will do, my lord? I cannot make it RCC, my lord, in top floor.
Have you got any definition of temporary?
Yes, my
structure?
lord. In our affidavit, my lord, I have annexed the government of Assam, my lord.
Which affidavit? Reply affidavit.
In our affidavit in reply, my lord.
Yes. Page.
Page, my lord. Page 19, my lord. Page 19, my lord.
Yes.
Introduce and definition. In notification, government of Assam ordered by Governor Urban Development Department is raised and for Assam notified urban area other than the Guwahati Pilda Builder 2014. So you will also kindly see page 21, 14 building. Page 21, my lord, building.
Page 40.
Page 21, my lord.
Yes.
Page 21, clause 14, my lord.
Building. Yes.
Sorry, section 14. Building means a structure constructed with any of the material whatsoever for any purpose, whether used for a human habitation or not, and include foundation, plinth, wall, floor,
Rule
roof.
214.
As your lordship,
Rule 214.
my lord.
Building.
Section 14.
It's not an act, it's rule.
Rule 14.
Rule.
Rule, sir.
Yes, the rule is called rule by yes. The rule is building rules, 2014, rule 14. my lord.
Building. Definition. Yes.
Foundation, plinth, wall, floor, roof, chimney, plumbing, and building service, platform, etc. Veranda, balconies, provided all types parts of building or anything affixed thereto, or any wall enclosing or intend to enclose any land or space, sign, and outdoor display structure, etc. Provided that all type of permanent building defined here, but structure of the temporary nature like tent, hut mat, as well as Shamiana erected for temporary purpose for ceremonial occasion with the permission of the competent authority shall not be considered as a building. So if it is used for temporary Shamiana, temporary my lord, thali, that will be temporary. But here my lord, there is a building plan. There is a, so that CIC is affixed in the building, permanent wall. So that cannot be termed as a temporary man. It is a building man. That CIC is also part of the building.
Any definition, legal definition of
Legal definition, my lord, as per a legal dictionary, my lord.
what does black say?
Yes, black say I'll click. Yes. Black notice.
Okay. Permanent fixed, continuing, lasting, stable, enduring. By
Not
the
subject to the same general appropriate law, temporary, but not
always meaning perpetual.
temporary. That page, my lord. I have the
Yes.
permanent, temporary, both meanings are there. Temporary, that which is last for a limited time only. As distinguished from the which the permanent, which is perpetual.
Yes.
In our building, my lord, it is fit with the permanent structure for a permanent period. My lord. There is not, it cannot be termed as a temporary, my lord.
Okay, okay. Yes. Anything else?
So that is my case, my lord. Your lordship kindly see, my lord, 8-7, my lord, they have totally, my lord, misinterpreted it, and my lord, their affiliation is, my
What is the present status?
my lord.
What is the present status?
Present, there is a stay order where college is running, my lord, and but, my lord, they have, my lord, another mischief they have committed, my lord. In their website, my lord, our college is shown as a, my lord, withdrawn. So that's why, my lord, students are suffering, my lord. Although there is a stay order, we are running, university has granted permission, but in the case of new admission, my lord, we are facing difficulties because last 2 years, my lord, their drop of admission, my lord, because of their attitude, my lord. In website, they should have shown, yes, there is a court case. There is a stay order from court. That is not been shown, my lord. This shown is, my lord, we done. The stay order was until further. That's why we are.
Okay.
Fine.
Yeah, please, your lordship.
Yes, yes.
My lord, your lordship may kindly say the recognition order, my lord.
Miss Debbie, you don't have much to say, I think. You're for NCT.
She is for, my lord, university.
You're for NCT. Okay. Which page
Page 26, my lord, that is the recognition
of your
of repetition, my lord.
of the repetition? 26.
That
Yes,
is
please.
recognition order, my lord. Passed on 25/2015.
25 to 15. Yes, please.
Made it.
Hmm.
Whereas in exercise of powers conferred by subsection 2 of section 32 of the National Council for Teacher Education Act 1993, 73 of 1993, and in suspension of the National Council for Teacher Education recognition norms and procedure regulations of 2009, the National Council for Teacher Education has notified the regulation of 2014 on 1/12/2014. That is come into force from 1/12/2014, my lord. Para2, my lord. And whereas the institution, namely Kamala Baisburwa Memorial College of Teacher Education, so was granted recognition for conduct of BEd course of 1 year duration with an annual intake of 100 from academic session 2005-6.
You read the relevant part.
Para3, my lord, that is the relevant. They have consented.
Yes.
And whereas the institution by Kamala Baisburwa Memorial College of Teacher Education College so has by affidavit dated 19/1/2015 consented to come under the new regulation of 2014 and sought for 2 basic units in BEd course which require additional facilities. And there is a conditions, my lord, para 4.
Hmm.
It has been decided to permit institution to have basic units of 50 students each subject following conditions, namely the institution shall create additional facilities that include additional build-up area, additional infrastructure, additional fund, adult staff norms, and as per regulations of and inform the regional committee with required documents by October 31, 2015. That is itself a condition, or there is a condition, my lord. And subsequent in para 8, my lord, also page 27, your lordship may found that the institute shall maintain and update its website as per provisions of NCT regulations and always display following as mandatory disclosure. These are the mandatory disclosures, including these, all these are, my lord. And subsequently, my lord, until the page 28, your lordship. If the institute contravenes any of the above conditions of the provisions of the NCT Act, rules, regulations, and orders made and issued thereunder, the institution will render itself liable to adverse action, including withdrawal of recognition by the regional committee under provisions of section 17(1) of the NCT Act. That order itself a conditional order, my lord. Thereafter, non-compliance of order, we have issued on 2 occasions notice. Ample opportunities were given to rectify their defects, my lord, but they have not been done. Accordingly, order was withdrawn, my lord. That was my seniors have already and apprised your lordship. And accordingly, appellate order also passed by withdrawing their recognition, my lord. Then, my lord, your lordship may come to our affidavit, my lord.
Mr. Alam, you hit on the issue.
Just, my lord, I have just pointed out.
We have boiled down to the particular.
No, only in respect of my affidavit, what is our stand, my lord? That is
No,
that I have submitted.
see, even
There
if
are
you
7, my lord.
Mr. Alam, even if you do not write the what you have just referred at page 28, even if that is not there, if there is a contravention of the rules, obviously you will have the power to de-recognize. You don't need to do this. Now your contravention, you have found a contravention in the form of the building, that it is not a temporary structure. You address on the court on that. Others have been taken care of.
But, my lord, as per our act, my lord, there is statutory provisions there, my lord.
You address
And
on that. What
your
is
lordship may kindly peruse the act also, my lord.
act? Yes. Act, you have part of the affidavit. No.
No, my lord, I have not annexed, my lord.
Maybe you have given on an earlier occasion. Let us see it. We may have the act. What is the name of the act?
National Council for Teacher Education Act 1993.
Yes, we have this.
Your lordship have. Then your lordship may kindly just pointed out your lordship, relevant section, my lord.
Yes,
Your
please.
lordship may kindly.
Yes.
Page section 12, my lord. That are relevant, my lord. Tell us.
One second. NC PE Act 1993. Section 12.
Section 12.
Section 12.
function of the
Function of
council,
the-
and then section 12A, my lord, and then
12A.
12A, section 13, my lord, inspection,
13.
14 is the recognition, my lord, how to recognize the institution, my lord. And section 17, my lord. That is contravention of provisions of the act and consequences thereof,
17.
17. And section 18 is appeal. And your lordship may also include section 32, that is power to make regulation. That is important matter, how the regulations will come into force. Section 32, my lord.
32.
In view of our NCP Act, my lord, your lordship may dismiss the petition, my lord, and I have also given one copy of judgment of Delhi High Court, my lord. It is also a similar letter. Your lordship may kindly peruse.
So what is the citation?
This I am collected from the online matter 2021 5 DL CK 0035.
Yes, which part? Which part? Which paragraph?
Paragraph 21, my lord, that is in respect of GI roofing, my lord. Although that college have a RCC slabbing, they have removed the GI roofing, but court have not accepted that plea, my lord. That is as para 22 and 23 is also relevant, my lord, and para 24 is the district order. So I pray for a dismissal order, my lord.
You have not addressed the main issue which has been raised.
In fact, my lord,
Is somebody disputing the provisions of the act and the rule?
in fact, my lord, they have violated the provisions, my lord. Since we have on 2 occasions, my lord, we have
How
issued a
is
stopper's
it
notice, my
simply
lord.
saying violation?
Violation in respect of, my lord, in our regulation, it is specifically stated that should be a permanent structure, my lord.
That is,
And,
you have to.
and CI sheet is not a permanent structure, my lord. It should be building, my lord, and building should be RCC slab, my lord. That is our only contention. And if we have allowed CI structure, my lord, in that case, we have violated our own regulation, my lord. In all the colleges, this is a pan-India regulation, my lord, and all the colleges have to abide.
In the amended portion, where is the portion regarding CI?
There is no provisions for CI sheet in our.
Where is the provision prohibiting CI after the amendment? And there was a order of this court for consideration under the amended act.
My lord, we have also already filed our additional affidavit, my lord. In additional affidavit, we have enforced the honorable court order as well as in compliance.
Exactly.
We have decided that.
Mr. Alam, you don't have the patience to even listen to the court.
That, my lord, in that case, my lord, I would like to, my lord, your lordship.
You are not addressing the moot question which has arisen for consideration. Is somebody disputing the provisions of law in the act? Is there in dispute?
My
There is
lord,
no dispute.
in fact, they have violated that provision, that regulation 87, my lord. Since
how is it been violated? You have to address on that. You are not saying anything. You are saying violated, CI sheet violated. How is CI sheet is not treated as a permanent structure?
In fact, in our regulation,
what are your reasons?
in fact, that is already in our regional.
Coming to a finding without reasons will not help. We are here to see the reasons, validity of the reasons.
But, my lord, in our regional committee meeting, my lord, we have decided that already, my lord, annexed with this That is in our additional affidavit, my lord. We have specifically stated, and with due regard to the amended regulation, my lord, your lordship already produced this, my lord, at page 31, my lord,
31 now.
of my additional affidavit, my lord. Internal page is 32, my lord.
Additional affidavit.
In the light of order dated 25/5/2022, my lord, the Honorable High Court in past instance original file
You are reading page
page 32, my lord. Relevant part is page 33.
relevant part page.
Page 33, my lord.
Yes.
And then your lordship may kindly come to page 35 and 30.
No, we have not seen. Where in page 32?
34 is another meeting, my lord. That is in respect of your.
No, we have not followed which paragraph you are referring. In your, we have your additional affidavit. Which page?
Page 32, my lord. That is
32.
your lordship may found it.
No, internal, say internal page.
Internal 32, my lord.
It cannot be 32. Internal
Affidavit
page.
dated, my lord, 21/10/2022.
We have that affidavit, 2110. The internal page.
Internal page 32, my lord. '31 starts, my lord. Annexure E, my lord.
31 it starts. Annexure 3. Annexure E.
E.
Correct. Then 32.
Page 32, my lord.
Yes, which part?
Keeping in view of the above,
Yes, yours is said withdraw.
decided the withdrawal of the order dated so and so stands quasi an institution is and thereafter benefited the condition of past withdrawal for past so and so. Oh, sorry, my lord. Page 32, last, my lord. In the light of the order dated 25/2/22 passed by the Honorable High Court of Guwahati in WPC number so and so original file of the institution along with the related document NCT Act 1993 regulations and guidelines issued by the NCT from time to time were carefully considered by the ERC, and the committee made following observations. The clause 8(7) of NCT regulation clearly mentioned that no temporary structure or just as roofing shall be allowed in the institution even if it is in addition to the prescribed build-up area. The matter was examined by the ERC in detail, and the committee was of the opinion the structure and roofing of the institution which is made by CL sheet cannot be considered as permanent structure in the light of the NCT regulation of 2014. It appears a temporary structure which cannot be considered in the light of the NCT regulation of 2014. Thereafter, again, we have decided the issue on page 34, my lord. That is on 14 and 15th in our regional committee meeting, my lord. Page 35, may I?
One. In the earlier meeting of 12th and 13th, you were not aware of the amendment.
That is, yes, my lord, in July, my lord, and amendment comes into force from my lord. May, my lord. So then we have again reconsidered the matter in view of the
Amendment was of 4/7.
4/5.
4/5.
4/5. We were not aware in July when the amendment had come in.
Subsequently, my lord, we have considered this with the direction of from this honorable court, my lord, in 14 and 15 September 2002. That is annexed at page 35, my lord.
One minute. Then you further considered.
Yes, my lord, at page 35, my lord.
Yes.
34, page 34, my lord, your lordship may found it ARC meeting dated 14 and 15 September 2022.
Yes.
Annexure F, my lord.
Yes.
And page 35, Komala Bajurua, Memorial, serial number 45, my lord.
Yes.
In the light of the order dated 25/5/2022 passed by the Honorable High Court of Guwahati in WPC number so and so original file of the institution along with other related documents, NCT Act 1993, regulations guidelines issued by the NCT from time to time were carefully considered by the ERC in the 306th meeting, and the committee made the following observation. Clause 87 of the NCT regulation clearly mentioned that no temporary structure or asbestos roofing shall be allowed in the institution even if it is in addition to the prescribed build-up area. The matter was examined by the ERC in detail, and the committee was of the opinion that the structure roofing of the institution by which made by CI sheets cannot be considered as permanent structure in the light of the NCT regulation of 2014. It appears a temporary structure which cannot be considered in the light of the NCT regulation of 2014. Matter was further heard by the Honorable High Court at Guwahati, my lord, that is Guwahati, my lord, typography mistake, my lord. And the Honorable High Court passed the order dated 38/2022. The operative part of the order is as under. Clause 87, the word asbestos had been deleted from perusal of the ERC meeting held on 12th and 13th July 2022. It appears that the consideration of the structure of the petitioner's college was made on the basis of the unamended regulation where the structure of the institution was regulated under the clause 87 of 2014. Since the 2014 regulation has been amended in the year 2022 with effect from 4/5/22, it is deemed appropriate that the ERC may directed to consider afresh in the light of the amended provisions of clause 87 of the NCT regulation of 2014. According to the regional director ERC, respondent number 4 shall take appropriate steps to place the matter before the authority for afresh consideration and structure of the petitioner's institution in the light of the amendment made in clause 87 of 2014 regulation, which shall be done within 4 weeks from today. The committee considered the revised provision of 87 of the NCT regulation of 2014 amended on 5/5/22, which provide 7. At the time of inspection of building, the institution shall be complete in the form of permanent structure on the land possessed by the institution.
Okay. How long will you take, Mr. Alok?
My lord,
How long will you take?
10 minutes, 10 to 15 minutes.
We'll come back. But you are yet to address on the main issue raised by Mr. Mahanta. Initially, there were many points. Now it has culminated, boiled down to only one point: definition of permanent structure and temporary structure. Whether a 3-storied building with PIC on the top can be regarded as a temporary structure. Only on that.
Item number 12, if your lordship please, hot matter.
My lord, permission to mention item number 15.
Yes.
After my learned senior counsel concludes the item, if my matter may be taken up, my
No,
lord.
we have a apartheid matter. We cannot take up this matter. Mr. Das, we have a apartheid matter.
Before he finishes, because he is a library assistant. Earlier, he appeared for the post.
But this matter we have heard for a number of days. We have to finish that matter. We are in the midst of hearing. We'll fix a date.
Fix it.
Let us see, Mr. Deputy Solicitor is waiting for this matter. Other side is already completed on our basis.
Thursday, man.
Thursday.
This Thursday.
Was only praying for my lord.
Interim will continue, man.
Item number
12.
12. A list on Thursday.
Very short matter, man.
Interim order passed earlier to continue to the next order.
I was only praying for my lord indulgence.
Mm.
I'm the review petitioner in item number 15.
Mm.
My lord, I'm an outstation counsel.
Mm.
I understand that there are matters fixed at 2 o'clock. If my matter may be taken up, taking the indulgence.
We are in the midst of a apartheid matter.
I will force that if it is possible for my lord to participate.
That not be possible. Yeah, he'll take whole day.
I follow.
You take your chance to get a chance. Who's on the other side?
My lord, we have done so.
Who's on the other side?
We have done the service, and I will just confirm from the instructing counsel. It is a
Yes.
review of my lord's judgment and order dated 23rd March.
What is the reviewer seeking?
By virtue of the impugn order, my lord has been pleased to pass
certain directions against the council, Mr. Khalbinder Kalsi. There is a fine of 50,000 as well. The matter has been referred for
We'll enhance the fine.
consideration.
We'll enhance the fine. How much was the fine?
50,000, my lord.
We'll enhance it.
My lord,
Argue. Okay, if that is the argue.
I'm on a very limited.
Yes, we'll enhance it. Argue to your own risk. We'll enhance it. You're serious.
Please, my lord.
We'll enhance it. We'll issue notice to you why it should not be enhanced. If you're arguing a matter of that nature,
I'm completely at my
where a
lord's will.
person argues for 6 years for a person who is not even there existing, and you're coming with a review, before taking up a brief, Mr. Counsel, think twice.
Please, my lord.
Please argue.
So, my lord, I have to seek instruction in that.
No, argue. You're seeking for arbitration, we'll hear you.
I'm at my lord PS. I'll have to seek instructions in that.
Please take instructions, we'll have it whenever you feel, but argue at your own risk.
I'm on a very, very limited aspect.
Whatever you,
Yes.
we have considered applied our mind. If we are wrong, we may have some other view, but prior aside, we are not with
Please,
you.
I follow. But I'll just take instructions.
And that is not an important matter.
Yes.
Why are you seeking time for upgradation? Is that an important matter?
Not at all.
You're an Austin council will give you some privilege, but not to that extent,
Please, my lord.
not at the extent of the cost of other lawyers.
Please.
Sorry,
I was only seeking my lord.
no, not in the matter of this. Yes,
I will draw my mention.
My lord, I beg to mention, my lord, item number 22, my lord, it will take some time, my lord, to.
Yes.
So, my lord, may I pray any date, my lord, lordship's convenience?
We'll see, the date he'll give.
My
Let us see how much time Mr. Dev Chaudhary takes.
My lord, because they have not filed their affidavit also, my lord.
You have to file an affidavit. How much time?
2 weeks, my lord, I not there the next week.
2 weeks.
Full to my lord.
You're for the department. Sri R. Mazumdar, the counsel for the elementary education department submits that he would require some time to file the affidavit of opposition. Full stop, para. In the interest of justice, list up to 3 weeks to enable him filing of such
My lord, the
affidavit.
date may be fixed, my lord, otherwise.
Matter is regarding what?
Regarding my lord, termination was issued, my lord, and I have not been paid my salary right from 2007, my lord, despite of the order of the magistrate.
That is the subject matter of challenge.
Yes, my lord.
As agreed to by the parties. Please, yes, tell us.
Any day, 3rd week of June, 21st, 22nd, any day, lordship.
Mr. Mazumdar, 23rd of June.
Lordship.
Okay. Date he'll give. If there is anything to be done, he'll give date. Don't worry. Yes. There was one matter fixed. I think that was the matter. Which you had,
Item number 19, my lord, item number 19.
what
There
was
was an
19?
order for the Dibrugarh University to produce the records of the selection.
Okay,
Because
Mr.
that
Borwa,
means
yes.
the governing body, we give it back to the governing body, it is maintained by them.
Yes, you're having the record.
The order was to the Dibrugarh University, so he must not have shirts.
You take instructions, okay?
Yes.
Uh,
Only thing is that, my lord, the order has been uploaded from another case. My lord.
no, we'll clarify those things. Those are not matters to be. There are very trivial issues. Don't bring in those. Sri R. Mazumdar, counsel for the Dibrugarh University, submits that though this court, while a previous order had directed production of the record, comma, he submits that the records are with the college authorities. Full stop. Sri B. Borwa, learned counsel appearing for the governing body of the college, submits that he may be given some time to obtain instructions, and if the records are indeed with the governing body, comma, he would produce the same. Full stop. There are at least after 2 weeks.
Yes.
We give a date. Who's for the other side? Who was there?
I had told them that we.
Who was there? Who was there? Item?
19, my lord. Mr. Ken Chaudhary and his team was there.
Which Chakraborty? Yes, Chakraborty. 18 matter. Okay, 2 weeks.
2 weeks.
Yes.
Obliged.
My lord, item number 23, my lord. This is 22, my lord, already taken, my lord. Just taking the partner matter, my lord. In this case, my last occasion, my lord, respondent is taking time to file affidavit, my lord. They have not filed yet, my lord.
Secondary education.
My lord.
Yes, who's for secondary? 23, item 23. Your affidavit is 23.
It will be on the after week, my lord, or on Friday, my lord.
So today, otherwise also it's not reached, will not reach. We'll have it on Friday, take instructions by Friday.
There is an interim order.
Our affidavit is fine.
Fine.
Sir, we have not received.
I'll confirm it.
Yeah, I have not received my document.
I'll confirm.
No affidavit actually.
Maybe yes, file for it. Maybe it's ready, my lord.
It's not with the tagged with the record. It's not tagged with the record. Check, Mr. Three R. Mazumdar, Planning Council, Secondary Education Department submit that the affidavit seems to be ready, and he prays for some time to obtain instructions regarding the status of its filing. Please after a week. Interim order, interim order passed earlier to continue to the next day only.
Deeply obliged. It is a lordship. Lordship in this in WPC 2723.
Yes.
The petitioner challenges a provisional attachment order. If I may take your lordship to page 134.
134.
134. 2723.
The prayer.
Prayer.
Yes, please.
It starts with C only. I don't know whether my one is wrong or lordship. It starts with C.
Yes, yes.
And challenges are the provisional attachment order of 30/11/2011. I guess it should have been 30/11/2021. And if your lordship will see the prayer lordship, A is in the last
Has to be explained that.
lordship. Now this relates to the affairs of the CMJ University. And on the last occasion, lordship, I had advised your lordship regarding the functioning of the university, how is it has functioned from its inception. I'll just recapitulate in a short time. Now,
Okay. Is the order date 30/11/2021, 2011?
lordship, this perhaps this is not correct, lordship. This is not correct. This is not correct.
You don't think that's correct?
They should have corrected it, lordship, before moving. In fact, it should have been point out. (30/11/2021).
21. It
It
should
should
be
have been 30/11.
601. Isn't it 601?
It is in 601.
30/11/2021.
Yes, that should have been corrected.
Because the submission which was made is that this ECIR number is identical with the earlier order of 25/4/2017.
Yes,
So 30/11/2021 is at page 601, I think.
it is at page 601.
Okay, please go ahead.
Now, so far as the functioning lordship, I will just take a few moments to for your lordship. This university was lordship established pursuant to a sanction at this is of 2010. And here, lordship, the
2010 the university started.
lordship, in pursuance of section 4.2 of the CMJ University Act 2009, the governor of Meghalaya is pleased to accord sanction of the CMJ University. No, under the act, lordship, they cannot have any off-campus centers and all those things. And here is a case where the university had started to give up the degrees even before it had started. Even before the university had started, because a degree course will be for a minimum of 2 years. Let us take the extreme 2 years. And the degrees were awarded right from the first year itself.
What do you have to substantiate?
Lordship, the police case on the basis of which this PMLA case has been taken up, the charge sheet itself substantiate that.
Let us come to that.
Lordship will find that page. Uh, 234.
234.
234.
Yes.
If your lordship has got it.
Yes, yes. Yes.
There's a chart, lordship.
Mm.
And 20,570 degrees and diplomas.
Where are you reading? 234? Which part?
234, lordship has seen the chart.
Chart, yes.
Lordship will go to the next page. 235.
235.
235.
Yes.
It's summed up.
Yes, yes.
20,570.
Mm.
And lordship will see the concluding paragraph at 235. The above degrees were all issued illegally either on cash payment or through a system of backdating, forging, and through fixed admission through illegal study centers or through UGC, DEC non-recognized mode of distant education. Bachelor degrees were issued in August 2010, and lordship has seen the sanction. I have just taken your lordship to the sanction. That your lordship in my affidavit at page 1054. नंबर केस तरी पण गेला नाही का Okay. Right. No, this is not a sanction. Lordship, if I may take the lordship to the paper book I had earlier submitted, I'll just correct the pagination in the new.
Doesn't matter, we can find it out.
No.
You refer to your page.
This is not telling with my
You refer to your page, we can find it out.
lordship. In the earlier paper book that I had submitted, lordship, at page 28, your lordship will find this.
What are you referring to? Just tell me.
This is a notification issued on 17 June 2010
Part
with
of
regard to
part of which pleadings?
lordship.
Part of pleadings of who? Which of the parties? It's in the part of the writ petition or your affidavit?
In my
In your
lordship, in the paper book I had given, I had put it on affidavit. Lordship, this affidavit pagination I have.
no, we have your affidavit.
Uh,
Yes, sir.
Lordship will find that at 105.
1059. Very. Oh, no. 955 would be Rosen. Isn't it? February 1059. 1059, yes, sir.
1059 lordship in my, that is annexure 3.
Isn't it? Okay,
1059 if my lord has got it.
This is the act. Annexure 3.
Annexure 3 lordship.
Is it the act you're
No,
referring to? What is, now we have an index, we can verify the index. Sanction, 1059.
Index also I find it wrong.
1059 is said in the sanction, but it's not there.
1059.
Annexure 3 is, you have given the act here. Index says it's some
It's a sanction. Index is
sanction,
sanction.
but 1059 is the act. Annexure 3. No, I think it's sanction maybe. Yes, correct. Annexure 3. One page document.
Yes.
Yes, sir. Oh, got it.
So my lord will find
17 June.
17 June 2010. So the university has to function after getting the sanction law.
And your charge sheet
Charge sheet lordship
says that August 2010, bachelor's degree were already issued.
already.
And the sanction itself was in June 2010.
Lord. That was basically the modus operandi lordship. You pay the money, take the degree. That was the system going on.
No, say, Mr. Dev Chaudhary, the scope of this writ petition is a very limited one. And that is their contention also. Their contention is that they are not against the action per se. They only want protection to that much of, to that extent that it should not exceed what the predicate offense is. The amount involved in the predicate offense and the proceeding which you have initiated.
That would be some 43 crores. and
Yes, they are not at this moment they are not raising the challenge for the amount which is confined to the predicate offence. They are only one that they should be given a leverage or a liberty to operate their bank accounts by keeping this much of amount intact.
No, Lordship. If that would have been the,
So that in that view of the matter, there is no requirement for you to defend your action regarding the predicate offence. In fact, we are also not making any comments.
Lordship,
Prima facie, you are making out a case that illegality were there.
Lordship.
And in fact, there were illegality, which of course needs to be established in the court of law after trial. That is so far as the predicate offence is concerned. Now, the fruits of the illegal offence is the subject matter of the present proceedings, isn't it?
Yes.
Now, they say that even if you assume that whatever you have alleged by the enforcing agency is correct, then also there are many other funds which they should be allowed to operate and have the university function.
Not whether the university is functioning. That is a.
And that's a moot question that you can address.
Your Lordship. And furthermore, Lordship, if they are limiting their grievance to only that,
Yes.
only that, what happens is it is referred to the adjudicating authority under section 8. The matter, once attachment is done, the matter is referred to the adjudicating authority. Adjudicating authority issues them a show cause notice. They have to reply. Now, the adjudicating authority may not go with the ED. If it finds fault with the ED, it will drop the proceedings. They do not want to go there. That is why they are solving the matter here. ED, the adjudicating authority will not suo moto or without hearing them take any decision. They will be given an opportunity. They'll have to reply. It will consider, and thereafter some order will come. And if some order comes, what happens? There is a way given out in the Act itself, which they can avail. Now, without coming to the court, they can do that. There is an alternative remedy available to them. Why should the court interfere? There are decisions which say that when this provision is a code in itself, then the remedies are also available in the code itself. They first ought to.
But the attachment covers everything.
Lordship.
Attachment covers everything. The provisional attachment order covers everything. They stop the functioning. What they are trying to impress.
Whether it is functioning or not, that is why I am submitting. Whether it is functioning or not. Because I have taken your Lordship to the order passed by the High Court of Meghalaya on the last occasion. That your Lordship will find.
Are you making a statement that the university is not functioning?
Yes. Legally, it cannot function. I'll take your Lordship to the order passed by the Honorable Meghalaya High Court.
Yes.
In WA 14 of
Page.
I'll take your Lordship to that. That your Lordship will find.
It's a part of your paper book.
It's in the affidavit. New affidavit I have filed. I'm just taking your Lordship. Your Lordship will find it at page 1131.
Yes.
And I take your Lordship to the concluding part. This is a case where Lordship, the university was dissolved by the state. And the Honorable High Court in appeal
This was a state's appeal.
Lordship, it was filed by the government of Meghalaya. Government of Meghalaya dissolved it. Now,
It was interfered by the single judge.
it was interfered by the single judge and the division bench reversed it. And I'll take your Lordship to the concluding part. Lordship will find it 1174. Lordship will kindly bear in mind, by this time, the university already stood dissolved. At this stage, I'm reading at 1174.
Yes. 1173.
73, Lordship, from paragraph 35 onwards, let me read. In the light of the above discussion, in our considered view, the impugned judgment and order cannot be sustained and same deserves to be questioned set aside. The learned single judge, however, only examined the decision of the state government for dissolution of the university on procedural requirements under section 48(2) of the said act and has not gone into the merits of the decision. Therefore, in our view, the matter is required to be remanded to the single judge to take decision on merits. We accordingly dispose of this appeal by passing the following order. The appeal is allowed. The impugned judgment and order dated 16/7/2015 passed by the learned single judge in WPC 177 of 14 is quashed and set aside. The matter is remanded to the learned single judge to take appropriate decision regarding the validity of the order dissolving the respondent university on merit. Learned single judge is requested to dispose of the writ petition as expeditiously as possible, preferably within a period of 6 months from the date of receipt of this order. The registry is directed to remit the paperwork. At this stage, Mr. A. Singh, the counsel for the respondent, requests for continuation of the stay granted by the apex court.
Yes, we have read this.
Lordship. Now, Lordship will see it is for 2 weeks. The last paragraph.
Yes, sir.
The 2 weeks expires.
This order is dated 6/5. 6/5/21, isn't it?
6/5/20.
Yes.
6/5/21. And Lordship will see what they have done. They approach the Supreme Court. And Supreme Court on the next page, 1165, 1175. Lordship will note the order 16/2020.
Yes,
16/2021. Issue notice returnable in the last week of July 21. In the meantime, status quo as it exists today, shall be maintained by the parties. Therefore, once it has been dissolved, within 2 weeks, there is no order. Status quo, near about after a month, it stands dissolved. Legally speaking, the status quo order has been extended time and again. But the implication remains the same, Lordship. Implication remains the same. Therefore, my submission before your Lordship will be, as on date, this university is not funded.
What was the subject matter of challenges for the Meghalaya High Court?
Meghalaya, Lordship, what has happened was the matter came back to the government and it had to take a decision under section 48 to dissolve the university or not. And it had taken a decision to dissolve the university. That was
The dissolution of the university was the subject matter of
before the
challenge.
single judge.
It was allowed.
It was. No,
Division bench.
the dissolution was interfered.
That is, repetition was allowed. The state to file an appeal. Appellate court interfered with the judgment of the single
Yes.
judge and directly remitted back the matter for decision on merits, because the earlier interference was on technical ground. Now, as on date, you want to contend that the dissolution was existing. The university was not legally functioning.
This was not legally functioning because it was 2 weeks window was given. And instead of pursuing the matter before the learned single judge, they preferred to go for an appeal before the Honorable Supreme Court. Therefore, legally, Lordship, this university is not functioning. Now, in so far as Lordship, their, I would say their admission for the predicate of 43 crores an hour. There also I have taken your Lordship from the earlier occasion, how orders were passed by the Supreme Court. There some money was withdrawn from the amount account. Then the Supreme Court directed to put it back into the account. Thereafter, the Supreme Court directed to freeze those accounts. But before the Supreme Court order had come, they had already taken out the money. They had already taken out the money. And where does this money go? I'll come to that also. Where does this money go? Because money laundering, it is not that I am doing some other business. Had it been university business, it's all right. This money goes to the promoters, the Jha family. They buy lands in Bihar, Darbhanga. I've given that. Therefore, they were trying to cover up these matters. And on the other hand, what they did was they were enriching themselves in some other part of the country. Now, if at all your Lordship feels that they may be permitted to operate those accounts, ultimately what will happen, whatever is there, that will also go out. At the first instance, Lordship, I had...
What about the submission that the amount involved in the predicate offense that can be kept intact?
Lordship, it is not a case that that amount has been kept intact. That 43 crores, hardly 14 crores remain as on date. They have taken out everything by giving misleading submissions in each and every court. And that was, Lordship, only the inception. That was a inquiry done by the CID, Meghalaya Police. But on our inquiry, Lordship, what we found is that the amount goes up to 83 crores an hour. From where this money comes, Lordship has noted, if we calculate the number of degrees, each person will be getting 1 degree. They will have to pay some fees, admission fee. It is not a regular degree, Lordship, just like we have got attending classes. A degree, a doctorate degree is given in 1 year or 2 years' time. Lordship has noted, degrees were issued in the first year itself. How, Lordship, no classes, even for the sake
So
of...
that is the reason we're asking you, how much will be approximate amount involved in the predicate offense?
Predicate offense, Lordship, in the Meghalaya case, 43 crores an hour. But on top of that, basing on the calculations, basing on the accounts that we have seen, it comes to, Lordship, 83 crores an hour. Once a handle is given out, because, Lordship, legally speaking, the university is not functioning. They do not need any amount to run the university.
They said that to pay the...
Lordship, I stand corrected. Police also found 83. Now the attachment was done of 43 crores and all. Two attachment orders there. Now, Lordship, I am told the submission has been made on
Are you clarifying that in the predicate offense, the amount involved is about 83 crores?
83.
Is it substantiated by the charge sheet?
Lordship. And I go to total to total. Here. Lordship, if I may take a look, page 246. That is a part of the charge sheet.
Yes.
Your Lordship will come to the last paragraph, 246, paragraph 9.
Two 246A or what?
And
246.
my one is 246. A. Let's know A, Lordship.
Good. Police will take it.
Hey, conception among the
Long to return come to Mari. Yes, please.
If I may read it. Based on 43 numbers of MOU entered with CMJ Foundation and the MOU between the CMJ University and the Apex E-Learning Bangalore, it is suspected that
You are reading paragraph 9.
9.
Please read.
That lakhs and lakhs of students have been cheated and enrolled in the non-recognized mode of CMJ Foundation sponsored university. This investigating agency managed to place 83 crores 52 lakh 68 crores as crime proceeds in the accounts maintained and operated by the accused Chandra Mohan Jha in the name of CMJ University. Now, Lordship, the next sentence. But as per bank account, 81 crores 89 lakh 6589 has already been withdrawn by the accused Chandra Mohan Jha, his wife. Now, his whole family comes into it. Chandra Mohan Jha, his wife, and his two sons, namely so and so. This investigating agency was able to freeze following accounts in the name of accused Chandra Mohan Jha and Indu Rani Jha, so, and also in the name of accused Prem Lal Rai, Sri Juban KB Katuri, so 43 crores 83 lakhs 70,191 only in the name of. So this 43 crores was initially, Lordship, it was the first attachment. This was, Lordship, done by the police. And the ED froze 27. And that is within that 43 crores. Now, Lordship has seen a university, let's, Lordship, for argument's sake, a bona fide university, just for argument's sake, 83 crores by way of fees and all we have collected.
Just a little clarification. You have referred to the status of the university as it's not functional. And to substantiate your statement, you have taken us to the window of 2 weeks, which was not availed of. Supreme Court order came on 1/6/2021, by which time that was over, and therefore there was no existing state. So it was in a state of dissolved state, which was, and under those circumstances, the order of status quo by the Supreme Court would only mean that it is still in the dissolved state. That is your submission. Now, what has happened to that proceeding?
Supreme Court.
Hmm.
Lordship, the order sheets that have been made available, Lordship, it's still in that. It's not finally disposed of.
That matter is still pending.
That ship is still pending.
And obviously, they have not gone back to a single judge. So, but at 1173, the division bench order of 6/5/2021
Lordship.
though the appeal was allowed, it was allowed only on the basis that the interference by the Honorable Single Judge was on a technical ground. So that appeal was allowed, decision of the Single Judge interfered with, and the matter was remitted. Now, what has happened to the proceedings before the Single Judge?
No proceeding as of yet. Lordship, they can better try. Is there single judge?
No, there is no requirement to initiate a new proceeding. This matter goes back.
No,
Like a division bench remitting to us, it has not proceeded over because of the Supreme Court order.
they have not proceeded so far as my instructions go.
No, we are.
Because now the matter is in the session of the Supreme Court.
That is it. We are in a situation C. Division bench interferes, remits back,
Flush.
giving certain, there's giving them some scope to pray for an interim order. And for that 2 weeks time was granted, then stay will be operative. After remission, they do not make such an application before the single judge to extend stay or pass a stay order. Instead, after the time of two weeks, almost after a month, they go to the Supreme Court. Supreme Court passes an order of status quo, by which time you say that the period of window of 2 weeks was already over. So it was a stage of already dissolved.
Flush.
So that has been continuing by status quo, is neither not benefiting them in any manner. Now the matter had gone back to a single judge, pursuant to the direction of the division bench. Now single judge matter is pending because of Supreme Court, or what has happened to the matter?
Lordship, perhaps because of the Supreme Court, because I do not.
Any idea? Please? That has been kept in abeyance.
So as on date, Lordship, legally, technically, Lordship, the university is not.
Practically.
Practically, Lordship, I do not know, they make a statement, but nobody sees any students. In fact, whenever I try to. As I had fallen from your Lordship on the earlier occasion, I moved into Shillong also. Try to locate.
But this is not in Shillong.
At that point of time, they were operating from a room. From a room in a commercial complex. It was not an university, Lordship, it was simply a room.
Not that way. On the last occasion, we remember.
Yes.
You had shown some photographs also.
Yes, Lordship.
But what about the Google map now? That expansion they are showing, the university campus.
Lordship, on papers, yes, they have taken a land. But Lordship, the university is not functioning. And Lordship, as I've taken your Lordship to the staff also at that point of time. 10 staff, one is not even a PhD, is a PhD scholar in another university, one is a registrar, one is a legal advisor.
We have not brought up.
Lordship, I will take your lordship.
Staff pattern we are not aware.
And this lordship, the period which we are involved right now will be from 2010 to 2013. Right now they may be having, but legally speaking, lordship, they can. And in fact, if they are admitting students now, that is at their own risk. Because they cannot do it now. And since we are, lordship, I will be concentrating on 2010 to 2013. Insofar as, lordship, the staff of the university is concerned, lordship, I take your lordship to taken your lordship to the orders passed by the Allahabad High Court, because what had happened here was students from UP and other states, they were taking admission here rather than we are much nearer. People from that place were taking admission here, and they had challenged these lordship when it was re-recognized. They had challenged that before the Allahabad High Court. And I'll take your lordship to 61 to 74.
They challenge this re-recognition of the university
Because their degrees were
were affected.
yes, lordship.
So they put the challenge in the Allahabad High Court.
Allahabad High Court said, I'll take your lordship there. Six to 95.
Yes, page
of
your affidavit.
Of my affidavit. I'll take your lordship to Annexure 15 at page 1092. And
yes,
I take your lordship to the second paragraph of 1095.
1092 is Allahabad High Court.
Yes, lordship. May I just read it, lordship, the second paragraph at 1095.
This is dated what?
It
This is the division bench order.
This is a single bench, then there is a division bench. I'll take your lordship to the division bench. This order is dated 1911. Your lordship will
I
find
think
that.
this is a division bench, I think.
No, the first one is a single bench.
Is it?
Vikram Nath 1095. A bunch of writ petitions. I think the division bench. One area. Court number one, lordship, it should be a division bench order. In any case, Lordship, let me take your Lordship to the second paragraph, the issue before the Honorable Court.
Hmm.
The questions,
No, you're correct. First one is a single bench, 1911-2013, which was the subject matter of bill for the division
the
bench at 1106.
yes,
You see the date,
yes, I have seen that date, 1911.
1911. See the first line of the division bench. Special appeal arises from a judgment of the
Yes.
single judge
Yes, yes,
dated 1911-2013.
yes. Lordship will note. I'm reading at page 1095.
Yes.
The questions involved in all these petitions are as to whether a degree of graduation in different subjects awarded by CMJ University Meghalaya, hereinafter referred to as the university, established by the CMJ University Act and recognized by the University Grants Commission under Section 22 of the University Grants Commission Act so and so is valid or not and can be treated to be a degree of graduation granted by the university duly established in the law.
Yes.
The issue was that, but thereafter, Lordship, I take your Lordship to page 1098. It starts with the paragraph on record. On record is available a letter dated 34/2013, written by the Governor Secretary Raj Bhavan, Shillong, to Sri Chandra Mohan Jha, Chairman CMJ Foundation. Under the 2009 Act, Governor of the state of Meghalaya is the visitor of the university. By the aforesaid letter dated 30/4/2013, after recording certain irregularities, directives had been issued under Section 13(3)(b) of the 2009 Act. The directives contained in the said letter are reproduced hereunder. Lordship will note, in view of the above, the Governor of Meghalaya, in his capacity as a visitor of the CMJ University, issues the following directions under Section 13(3)(b) of the CMJ University Act 2009 for immediate action, immediate compliance. The CMJ University shall recall, withdraw all the degrees awarded so far and publish this fact in national and local newspaper at their own cost. Because by this time, the governor became aware of what was happening. And in fact, here is a university lordship where the promoter nominates himself to be the chancellor of the university, which the governor had rejected 2-3 times. Governor said, you give the name of some other person who's a qualified person, but he had nominated himself to be the chancellor. The CMJ Foundation shall submit fresh proposal for appointment of chancellor, along with correct biodata of the candidates recommended and supporting documents. This is precisely what I was saying. He had nominated himself. The CMJ University shall frame rules and procedures for admission into MPhil and PhD degree programs, allocation of supervisor, coursework, evaluation, so and so. No fresh admission of students shall be undertaken by the CMJ University till compliance of the above instructions and till appointment of the chancellor in accordance with section 14(1). Till now, Lordship, there is no chance. Mr. Jha is the self-nominated chancellor.
He cannot be the chancellor.
It has to be approved by the visitor.
No, he doesn't have the qualification. You need to have special qualification to be a chancellor.
Lordship, there
Number two, is there any bar for the promoter to become a chancellor?
Lordship, it is not a bar, but then it has to be.
What does the act prescribe?
It has to be.
What does the act prescribe?
I'll just take it up.
But nonetheless, the governor took a call.
No, governor
that needs to be a change.
Lordship. And Lordship will see just below that. You are hereby required to comply. So it appears that reply dated 21/5/13 was given by the University Foundation to its council. Now, university replies to its council. The Governor Secretariat again reiterated its stand and white letter dated 24/5/13 and referred to further irregularities coming into notice and expressing serious displeasure and issued 6 directives under section 13(3)(b) of the Act. In view of the above, the Governor of Meghalaya in his capacity as visitor issues the following further directives under so and so.
Second letter 24/5/13.
Lordship. Now I take your Lordship to page 1100. Point number 5. The commissional omissions of the university are in 2 parts. It started functioning without the chancellor whose appointment has not been approved by the visitor. And it functioned in gross violation of the standards and norms set by the University Grants Commission and other regulatory bodies, CMJU Act 2009 and Meghalaya Private Universities Regulation, Establishment and Maintenance of Standards Act 2012. This is even more serious and offensive. It constitutes a breach of trust in addition. Even with legally appointed chancellor, no university can be allowed to function with such fraudulent intent and vitiate the academic environment, disgrace the institution of higher learning and bring disrepute to the state wherever it is established. Then 6(1) Lordship will see. On the basis of the facts and circumstances available, it is concluded that the university has committed the following grave irregularities. The university functioned from 17/10/2010 with self-appointed chancellor without the approval of the visitor in terms of section 14 of the CMJ University Act on the presumption of deemed approval by the visitor. This is not legally valid and the position has been affirmed by order dated 16th May 2013 of the Honorable High Court of Meghalaya, which has further been upheld by the Division Bench of the Honorable High Court of Meghalaya in their order dated 31 May 2013. Now, if I may take your Lordship to, I'll just read 2, 3, 4 and 5 apart. It has awarded B.Ed degree through distance mode without the requisite approval of the regulatory bodies and without affiliation. The B.Ed degrees awarded by the CMJ universities were held to be invalid in the eye of law by the order dated 24th May 2013 by the Honorable High Court of Guwahati. The Shillong Engineering Management College. Now, what happens is the Shillong Engineering Management College was affiliated by the NEHU, but again affiliated by the CMJ University, which itself, its authenticity is in doubt. Thus, college which was in existence prior to the sanction of the establishment of CMJ University cannot be affiliated with the CMJ University. While the fate of the students of this college was already uncertain in view of the said de-affiliation, the college continued to make admissions by misleading students that the degrees will be issued by the CMJ University. The university had reported that during 2012-13, it had awarded PhD degree to 434 students and enrolled another 490 students. These figures, though extraordinarily high, do not reflect the correct position. Information is available with us that another 29 students have also received PhD degree from the university, and more information is coming on a daily basis So it is obvious that the actual number of award of an enrollment for PhD and other programs will be much higher than what was reported. The university awarded PhD even in subjects like Boro and Punjabi language, where the guys faculty are not easily available. Now, Lordship, CMJ University in Meghalaya gives and violation of the UGC minimum standards and so. Now, 5 Lordship will make a mark. The university has furnished a list of 10 faculty members with PhD, which is inaccurate. One of the faculty members is only a research scholar. He himself is a research scholar and he guides others to take a PhD degree. He's only a research scholar at NEHU. The list includes the vice chancellor, registrar, and other functionaries of the university as faculty, which is quite misleading. In fact, the university does not have adequate teachers to introduce courses which it had been doing. Now, if I'll take your lordship to the charge sheet at one point of time, where your lordship will find.
So, Mr. Devchodri,
Lordship.
The findings of paragraph 5
Lordship.
is not conclusive to mean that you say that the number of 10 faculty members whom the university claims to PhD, that is inaccurate. The second line is a separate line. One of the faculty member is only a research scholar of NEHU. That means 9 can be PhD scholars.
9 can be PhD. It does not. But one is not a PhD degree holder.
Only you have said that only one is a research scholar. 9 can be PhD.
9 can be, but
that is not a very substantial ground. I think.
The lordship will kindly recollect how many PhDs they have given with the faculty of 10.
No, that is not the allegation. Allegation is this.
Yes,
that having 10 numbers of faculty members with PhD is inaccurate.
I will show that.
That means that there may be less.
I will
but
show.
You have not said that none of them are who have the degree of PhD.
I will refer to them, lordship, when I take your lordship to the charge sheet once again.
Then off campus, off campus.
Off campus is here, lordship. 6. The university is running several off-campus centers, also so and so, which is not permissible under the UGC establishment so and so. It is offering distance education program outside of this. These are all appropriate, lordship. From
This is in violation of Professor Yaspal judgment.
Lordship. Now I will take your lordship to page 1102.
Next page.
Next page. Point number
11.
Point number 8, 11. 8 lordship will see. Total students enrolled by CMJ University as per information submitted by the university is 2010-11 176. Now lordship will collate this with the how many degrees were issued in 2009-10, chart in the dash sheet, which I had taken. Just lordship will bear that in mind. I will take it the lordship once again. 176, 2000.
You have said in 235, 20,570 illegal degrees. You have not said in which period?
Lordship, I'll take it. I'll grab it.
We think what you are trying to hint upon or harp upon, that number of students were not even that. It was much less than the number of degrees. But the degree is the sum total of the entire period.
Now, what is actually shown on paper may be less, but the amount of these, the number of degrees would substantiate otherwise.
Hmm.
The degrees issued and the numbers given to the governor are different. Now, may I take
No, you may have a point because the sum total from you, because you have said in at the outset that you are interested for the period 2010 to 2013, where the total number of students would be 274 plus 469 plus 176. That much, nothing more than that.
That is what.
And the degree is which is given 20,000. Now that may make a point. So 2270, this is 3,000,
This
31,000,
do not compare, Lordship.
31, then 32. At best, 3,300.
Lordship. This is, Lordship will again note, this is enrollment. That is the degree given. Therefore, without being enrolled, a degree cannot be given, Lordship.
That is it. 3,300 is the total number of students even giving on taking on the higher side.
Lordship.
You offer degree to 20,000 students. That means you have sold degrees who are not even enrolled into your university. That is what you are trying to do.
I would put it in a rather different
This
way.
20,500 was for is it for this period?
Yes.
Let us again confirm.
Yes. Because charge sheet.
From 235. (92 LLM also. Anyone in this code?
Lordship, may I like to read page 236, if I may read. Further, the above degrees of around 2570 were all issued illegally in so and so outside in non-regular mode, because Lordship, since they were operating from a room at that point of time, the question of holding classes would not be illegally in non-regular mode and outside the Shillong main campus, which are highly illegal as per so and so regulation and 2009. The CMJ University is allowed to conduct education only in its main campus, that is Modrina Mansion, that single room. Modrina Mansion, Laimukra, Shillong, and cannot go beyond its main campus even within the state of Meghalaya before completion of 5 years from the date of its establishment. And that too, it has to receive prior approval of the UGC. The CMJ University was established only after it got the sanction for establishment from the governor of Meghalaya on 17/6/2010. But by August 2010, the CMJ University had already started issuing all types of degrees in illegal and so. And this list, Lordship, which we were just referring to in the Honorable Court's order, that would only reveal 2734 at the bottom of the page. Now,
2734 is only for the year 12-13.
I'll be concentrating to only till 13.
This is exactly the extraction
Yes.
at page 1102.
Yes.
11-12 469,
Ah.
10-11 176, and 12-13 2734.
Now, may I take your lordship to the bottom paragraph at page 1102?
Hmm. This act is a central act of what? CMJ University.
State. It is state act. Because the state government has let me take your lordship to 1102, the bottom paragraph. State. It's a state. For the white covering letter dated 12/6/13, the principal secretary to the governor of Meghalaya enclosed the detailed fact sheet on CMJ University and also the copy of the decision of the visitor to the UGC. On receiving the visitor's decision, the chairman UGC constituted a committee chaired by Professor Mihir Chaudhary, Vice Chancellor Tezpur University, Tezpur, and 8 members of eminence and repute to visit the university and make on-the-spot assessment of fulfillment of criteria in terms of programs, faculty, infrastructural facility, financial viability. The said committee submitted its report on 1/8/2013. The observations of the committee as also its recommendations as contained in the report are reproduced below. The UGC committee, what it says, the university appears to have functioned from a hired building being shared by several commercial agencies. The inner part of the building is shabbily maintained. Security, fire safety, hygiene of the premises are practically absent. In the view of large number of students, now they show a large number of students. In view of the large number of students and faculty members as claimed by the university, which could not even be verified, the space used by the university is grossly inadequate. No academic ambience was visible. No students' amenity in the form of recreation room, canteen, so and so were found. Since no interaction was possible with any of the stakeholders, and since no academic ambience was discernible, the committee has serious doubts regarding claims made by the university on running the different academic programs. Consequent upon the observations made above, it appears to the committee that it should have been the committee that the complaints received by UGC are likely to be correct. Recommendations of the committee in view of the fact that CMJ University does not have requisite infrastructure for running all academic programs, as well as the fact that large number of complaints have been received by the UGC, highlighting the deviations from the UGC norms and standards, the committee strongly recommends that appropriate action be taken by the UGC. Now, what does the court ultimately hold? Worship will see on the next page, 1104, the bottom 2 paragraphs. The visitor of the university has already taken a decision regarding cancellation of the degrees awarded by the university from 2009 to
1104.
1104.
Yes.
The visitor of the university has already taken a decision regarding cancellation of the degrees awarded by the university from 2009 to 2013, as incorporated in its decision reproduced above. Photographs have also been placed on record to show that the university runs from a commercial complex which houses several other commercial setups. It has already come on record in the various reports that the university has no infrastructure but functions from a tenanted accommodation. There is no space for accommodating the large number of students and the faculty as projected by it, and there is no environment for studies. Here's Lordship, somewhere I will point out later on, Lordship. The Allahabad High Court had in fact sent a committee to verify, and they had apprised the order. In view of the facts narrated above as are apparent from the counter affidavit and records produced by the Learned Council or the UGC, the court is not at all inclined to further jeopardize the career of the petitioners. They have already suffered enough, although voluntary. But from all the facts narrated above, even on the technical grounds raised by the petitioner, they cannot be made to suffer any further and suffer any more. Further, it is difficult to treat their degrees to be valid for the following additional reasons. All the petitioners are residents of Uttar Pradesh. Meghalaya is a distant state situated in the northeast region, at least 2,000 kilometers away. The petitioners have to bear a heavy burden to establish first that the process of admission to the undergraduate course was in accordance with the ordinance of the university, the amount of fees deposited by them, the fee receipts issued by the university authorities or by any study center, whether within the territorial jurisdiction of Meghalaya or situated outside the territorial jurisdiction of the state of Meghalaya, the running of courses, holding of the courses, theory and practical both, training upon the nature of the subject, the attendance given by the petitioners, the mode and the place where the examinations were held, and thereafter the issuance of degree. The court does not find any material in the above regard on record. The inference has to be drawn adverse to the petitioners, which also finds support from the various letters and orders issued by the governor of the state of Meghalaya and the visitor of the university, as also the inspection report of the high-powered committee constituted by the chairman UGC. If ultimately the UGC declares the degree granted by the university to be valid, the petitioners would be at liberty to approach this court, and even then they will have to satisfy the court about the observations recorded in the preceding paragraph. Now, the division bench also upheld the order of the learned single judge. No interference was made, that your lordship will find at page
1115. 1115.
1114. It starts from paragraph 12. We are not inclined to differ with the view of the learned single judge for a number of reasons. First and foremost, the exercise of powers conferred on the visitor under section 13(3)B of the Act, which mandates that the directions of the visitor shall be binding on the university. Extensive directions were issued to the university based on the serious doubt and cloud cast on the credibility of the university relating to the unavailability of infrastructure, the grant of illegal admission, and the absence of faculty. Independently, the UGC also verified the existing infrastructure by an on-the-spot assessment, and the report of the expert committee is indicative of the fact that the university functions from a hard building, which is shared by certain commercial agencies. Infrastructural facilities are practically absent, and virtually no academic ambience exists. The visitor has, in terms of provisions of section 48 of the Act, recommended the dissolution of the university following the following which the Supreme Court has by its order passed in SLP of the CMJ University observed that the state government is required to take action under Section 48 of the Act. Now, the single judge's order, Lordship will remember, Meghalaya High Court. It was pursuant to this. The proceedings before the single judge. There is.
Now, what is the meaning of this 1115 paragraph 12, the last two sentences? The visitor has.
Lordship is reading.
Third sentence from the top, internal page 10, 1115.
Lordship.
The visitor. The visitor has.
The visitor has, in terms of the provisions of Section 48 of the Act, recommended the dissolution of the university, following which the Supreme Court has by its order passed in the SLP of CMJ University Foundation observed that the state government is required to take the action under Section 48. He has made a recommendation. The formality has to be done by the state government.
No. Where is this order of the Supreme Court by which the matter was left to the visitor to initiate a proceeding under Section 48? The order which you had shown was the status quo regarding dissolution. That means here is the earlier Supreme Court order.
This is earlier. Status quo was after this matter goes to the learned single judge. Single judge interferes with the order.
That is the second proceeding.
That is the second proceeding. Then division bench.
But where is the Supreme Court?
This Lordship, I'll find. Perhaps they would be in a better position there first. Now, here, Lordship, the university is required to create an endowment fund under the provisions of the Act. Now, how that is done by this university, I take a lot, because this visitors report, which has been quoted by the Honorable High Court of Allahabad, that also refers to the endowment. I'll take your Lordship to that. That's it. Lordship, I got it. No. Excellent. The paper book, Lordship, which I had submitted in the earlier occasion. I'll just read out what they had done is they had created an endowment fund on 20/5/2010. 20/05/2010. Totaling lordship of 210 lakhs, that means 2 crores 10 lakhs. Just for the sake of, because the university has to have an endowment fund under the provisions of that, to create an endowment fund on 25/2010. And what they do is, they close it by 21/5/2010.
Twenty
21/5/2010. That means,
next day.
yes.
Next day, very
Yes.
next day.
Now on papers, lordship, the fund is created. On the very next day, it is prematurely closed. That means that if at all the university was functioning, it was functioning without an endowment fund, which is contrary to the provisions of that. There's a report by the principal secretary to this effect. Lordship, I'll place that. There you go. It's okay. Just mark it. Now, what had lordship had earlier fallen from your lordship to allow them to function, to operate? Lordship has seen how this university has been functioning. In one day, they open an account, next day they close an account, 83 crores collected, 81 crores gone to the promoters of the university. That means the university, if at all, was left with only 1 crore something, because 81 crores have been withdrawn. Now there is another order of the Allahabad High Court, which also lordship, I may just take your lordship to that. But your lordship will find at page 1118. This also, lordship, goes in the same way as the earlier orders. I'll just read out the operative paragraph that your lordship will find at 1122. Paragraph 11. From the facts and circumstances, lordship has got it.
Yes.
1122. From the facts and circumstances, it is apparent that the persons in charge of the university had paid a fraud, of which the petitioners are the willing beneficiaries. They are running the university from a commercial complex in which large number of other commercial activities are running. The petitioners had taken admission in a university in which there was no infrastructure. The observations of the committee which inspected the premises shows that there is no space even for the staff to sit. In the commercial complex, the question of taking admission, running classes, and holding examination therefore does not arise at all. It is apparent that the entire setup was a fraud played upon the students, of which they cannot get any advantage as they are the beneficiaries of such fraud. The office of the university has been sealed and the persons in charge of its affairs were arrested and are in jail, we do not find any good reason to intercept. Now, having set out how the university has been conducting insert lordship, it is quite apparent that it has given a go-by to the act, the rules, and it has circumvented its ways through the various orders of the court, which, lordship, I would say they do not, lordship, their conduct itself would demonstrate that they do not call for any lordship order in their favor. I'll just the Supreme Court order lordship to take action under 48, section 48.
Yes.
Lordship, I petition lordship page 350. Annexure 20.
Yes.
This is an order dated 13/9/2015. This case was referred by CMJ University against the state of Meghalaya. And to take action, lordship, page 356.
What is this 350? The content? Order of the Supreme Court?
Lordship, lordship will see.
Petitioners in the concerned petition are permitted to file specialty petition.
These lordship will come below.
This wasn't a specialty petition. This was.
Yes. Lordship will see the next paragraph. The petitions are directed against the judgment dated 31/5/2013 of the Division Bench of Meghalaya High Court, whereby the appeal against the order of the learned single judge refusing to quash orders dated 13/34/2013 passed by the Principal Secretary to the Governor of Meghalaya under Section 13(3)(b) of the CMJ University Act for short so and so, where it was dismissed during the pendency of the appeal. Now, these are the extracts of the governor's lordship of those letters. And I take your lordship to page 356 for a moment. In terms of the recommendations made by the visitor governor, the state government is required to take action under Section 48 of the 2009 Act. Sri Anjan Mukherjee, Learned Counsel appearing for the government of Meghalaya, says that he is not in a position to make a statement whether the state government has taken action in furtherance of the recommendation made by the visitor come governor. In view of the above, we feel the ends of justice will be served by directing the state government to take an appropriate action under Section 48 of the 2009 Act after giving notice and reasonable opportunity of hearing to the 48 is the provision relating to this. Now I take your lordship to the provisional attachment order. Dated 30/11/2021. The lordship will find out at page 601.
Yes.
That is at page 601. And for a few statements that I had made regarding lordship, that amount that was freezed by the ED, 27 crores 66 lakhs. Out of that, 43 crores frozen by the CID. I'll just take your lordship to page 625. How they have played with the various codes.
$625, yes.
I'll just read from the top. 5.7 your lordship.
Yes.
As per the table provided above, prepared from the bank account statements received from the Punjab so and so, it is observed that CMJ Foundation deposited a total amount of 15 crore 10 lakhs as FD in the bank branch in between 9/3/2017 and 24/3/2017.
How long will it take?
1 hour.
They have to rise at 4 o'clock.
Lordship, let it be on. I'll just take your lordship. Actually, I am done. I'll just take your reason to believe.
Yes, those two, the legal grounds of challenge you have to meet.
That lordship will give me one and a half hours.
Purohit case.
Lordship, not on Friday. It may be on Friday. Thursday,
Friday,
lordship,
the second civil bench is not there.
lordship,
So Fridays, Wednesdays will be
Thursday, lordship, many matters are fixed.
then next Tuesday. Maybe.
Tuesday is fine. Maybe, Thursday, lordship, many matters.
What about you? Next Tuesday. And you can also complete your rejoinder. As an exceptional circumstance, you can address some virtually. But normally, virtually, this court is not doing this. You continue for 15 minutes and we'll rise up. Complete the factual aspect so that you
Lordship,
can.
those were basically done.
We are on 625, paragraph 5.8.
On I would like to go from lordship page 619. Lordship.
619. Okay.
Just for lordship getting a hold on what were the amounts, how the amounts were deposited. I'll just read out paragraph 5.1. In the case of CMJ University, the CID Meghalaya had registered FIR number so and so. The proceeds of crime in this case, as determined by the CID Meghalaya, is 83 crores 52 lakhs and odd. Charge sheet. The case was charge sheeted in the Honorable Court of the CJM Shillong by so and so. During investigation conducted by the CID Meghalaya, they had seized or they have freezed various bank accounts of CMJ Foundation, CMJ University, and personal accounts of CM Jha and his family members worth 43 crores. Lordship will just make a mark. 43 crores 29 lakhs and odd. However, the High Court of Meghalaya wide order dated 13/10/15 released an amount of 15 crore 62 so and so. Out of the frozen amount of rupees 43 lakhs, 43 crores
Hmm.
amount to meet financial obligations of the CMJ University. On the basis of the FIR lodged by the CID, Meghalaya and ECIR was registered by the Enforcement Directorate by so and so dated 7/17 in the name of so and so. Provisional attachment order by the Enforcement Directorate Guwahati was passed on 31/3/17, which is the subject matter of the other revision. For 27 lakhs, 27 crores, 66 lakhs, 77.
Which is the other petition?
There are two writ petitions. This can take care of that. Which was the remaining amount after release of 15 so and so out of the CID Meghalaya's frozen amount of so and so. So 15 crores and odd was directed to be released. Whatever remained, that was attached by the ED. Thereafter, the directorate filed OC number so and so. The account wise breakup of rupees so and so, on which provisional attachment order was passed on 33/17 is this is given. Then at page 622. However, on 22/6/17, the Honorable Guwahati High Court passed an order staying the adjudicatory proceedings under Section 8 of PMLA. Further, an order dated 28/9/18 was passed by the Guwahati High Court staying summons dated 26/9/18.
622, which part are you reading? 5.4.
5.4. 5.4, Lordship. Again, by an order dated 17/11/20, the Honorable High Court state the summons dated 14/10/2020 issued by the Enforcement Directorate to Govind Jha, Gopal Jha, Indu Jha. An application petition to so and so is substituted. Against the order of the Meghalaya High Court, now Lordship, this will be very interesting. Against the order of the High Court of Meghalaya, Shillong, dated 31/10/15, the state of Meghalaya filed an appeal with the Supreme Court, and on 8/4/2016, the Supreme Court ordered for depositing the funds of rupees 1562,43,477 back to the same account, which were frozen. However, the same amounts were never deposited back to the same accounts as confirmed by the Axis Bank, Laimokra branch, email so and so. Now, what they have done is, although the direction was to put it back to the same bank, they deposited it in Delhi. That will come later. To the same accounts as confirmed by Axis Bank, Laimokra, so and so. Again, an order was passed in CID case number so and so by the learned Chief Judicial Magistrate Shillong, dated 13/5/17, defreeze the frozen amount after accepting that CMJ Foundation has deposited 15.10 crores in compliance with the directions passed by the Supreme Court and had produced proof in front of the court of the Chief Judicial Magistrate at Shillong. A statement is made that they have deposited, all right, they have deposited, it was supposed to be deposited in Laimokra, they have deposited it in Delhi. On the basis of that, the learned CJ directs to defreeze the frozen accounts. The Honorable Supreme Court, by order dated 8/4/16, had given directions to the trial court to treat the matter of disbursement of the funds from the frozen account in consonance of law. The detailed deposit was of 15.10 crore was sought from the Punjab National Bank, Greater Kailash, New Delhi, which is tabulated below. Now, the money was supposed to be deposited Axis Bank, deposited in Punjab National Bank, Delhi. Now, Lordship will see 5.7 at page 625. how they circumvent the orders of the as per the table provided above, prepared from the Axis Bank, from the bank account statements received from Punjab National Bank, Greater Kailash, it is observed that CMJ Foundation deposited a total of 15 crore 10 lakhs as FD in the bank branch in between 9/3/17 and 24/3/17. This was in violation of the Supreme Court's direction that the amounts were to be deposited back to the same accounts from which they were withdrawn. However, as seen from the above table, all the accounts amounting to 5.10 crores were closed on 5/5/17 before the direction of the Honorable Supreme Court. What they have done is they have already withdrawn the amount. Further, it has been observed that CMJ Foundation took loans in account number so and so to the tune of 10 point so crores to part finance those FDs. These loan accounts were all closed on 5/5/17. Now, Lordship will see to deposit some money. They take loan from one bank, they deposit it in this bank. This money they withdraw, that loan they close from where they have collected the money and deposited. Lordship is getting. Supreme Court says you deposit the money.
Initially, all the Axis Bank.
Deposit the money. All right. You do not deposit it in the same bank, you deposit it in PNB. How do you deposit? You finance that deposit taking a loan from another bank. You take the deposit, keep it for a few days, you break those deposits, and you close that loan which you have taken to make that. Thus, based on 5.8, Lordship,
5.8. That's based on.
Lordship, it's 5 minutes. Should I continue?
This paragraph you can continue.
Thus, based on that order, in GR so and so, where the Chief Judicial Magistrate Shillong, it is 3/5/17, the accused persons not only withdrew 15.10 crore deposited as FD along with the accrued interest on 5/5/17, but also withdrew an amount of 12 crore so and so from the accounts attached to the Enforcement Director. Now we attached an amount of 27 crore. Now taking the order of the learned CJM, what they do is they not only withdraw that 15 crores, they also withdraw another 12 point something, which we had attached from the accounts attached by the Enforcement Directorate of rupees so and so, 27 crores 66 so and so. After withdrawing these rupees 12 crores 79 lakhs and all, the accused have laundered the same by transferring a huge amount of money from the Axis Bank account of CMJ Foundation to an account of CMJ Foundation in IDBI Bank. Now, that money is taken out. As soon as it is taken out, it is transferred to another bank, IDBI Bank. Now, Lordship has seen Axis Bank, Punjab National Bank, then again Axis Bank, now it goes to IDBI, from which huge sums have been converted into DDs and then laundered. By 30/12/2017, entire money transferred to this account has gone out. Now this is their account. Hence the accused misdirected the court of the Chief Judicial Magistrate Shillong by not letting the court know that the Enforcement Directorate had passed attachment orders on the said accounts which were allowed to be defreezed. They suppressed this in a court of law. There is also reason to believe that the accused have manipulated the bank officials for the release of the amount, as the bank officials were very well in the know of the attachment orders and were directed by the Enforcement Directorate not to release the amount. Thus, the balance amount lying in the accounts which were under attachment by the Enforcement Directorate stood at 14.87 so and so 83 crores. And these manipulations, the ED is left with 14 point something. So, Lordship, while adjudicating these matters, Lordship, we'll have to keep these things in the.
And one more submission was made, if you have been instructed and briefed in the meantime, that they're not seeking any final relief here in this proceeding.
They should go to
No, they are not seeking. They have said that pass an order to keep the PMLA proceedings in abeyance till the trial in the predicate offence is complete. Unless you come to a conclusion whether they're actually guilty of the predicate offences, then, and that is the first submission. Second is that the securities which have been directed to be given to be accepted by you, and the attachment to that extent till it covers the predicate offence, those should be refreezed and they be allowed to utilize the dam.
I will address your Lordship.
I think they have also understood the scope as
because Lordship will kindly note, you will remember what security they have given.
land document.
The land documents were Meghalaya. Now, to open an institute, Lordship knows Meghalaya nobody can get land. To open an institute, maybe they have manipulated the government machinery to give them.
No, those are original documents. You can verify those.
No, I've seen those. In fact, will they go to the extent of giving security of the lands that they have purchased in Bihar? They will not, because that land is in Meghalaya. Ultimately, Meghalaya will suffer.
No, you can authenticate those documents. Those are in the court records, I think. Mr. Singh?
That I have seen.
Mr. Singh? Those records are in the documents which are. We can head it over to you.
That is.
If that is done, then in the equity court, they will not get anything. They cannot play fraud with the court, of course.
Lordship,
I don't think they will go to that extent.
Lordship will consider, because Lordship, here I will take your Lordship to the lands that they have purchased through this money in Bihar. Not a single word has been said about that.
No, you may not. There cannot be a choice of which land you are interested. If your amount is secured,
that would not be the objective.
No, we are not on the merits, of course. But what is making some sense is that since the predicate offence is still at the stage of realm of allegations, those are not been established in a trial, at least the first court. Unless that is established, debarring them from complete use of the proceeds, complete use, they have the submission has gone to that extent. The scope has been reduced, that even to the extent that the amount involved in the predicate offence, then those can still be kept intact, if that is a possibility.
Lordship has seen it has come down to some 14. Attachment is 14.
They said the land value is something.
Lordship, land
20 crores.
Lordship on.
You also have a look at the, if you want, we can facilitate you to have a look at the document.
No,
and have the documents verified also.
They have shown.
You can get the things verified, whether the purchase was properly done or not.
Also, the bonds that typify that are also.
This matter will not go by indemnity bond.
Also, my lord,
Yes.
we were also on the point of the second or OC that they have
No,
besides
there is,
stay operational.
there is no bar of being there being a second attachment. for the same
Let him
person.
complete, then we'll try to have your rejoinder. Sri Arkiti Chaudhary, the learned deputy SGI, appearing for the respondent, have addressed this court. So, however, these submissions have remained inconclusive, and he accordingly prays for some more time. Prays for prays for another day. As agreed to by the parties, please for further consideration on
Tuesday, Lordship. I'll take one.
yes, they are proceeding. Interim order passed earlier to contribute in the nature of
My lord, if also the question of additional surety arises, I would suggest that we can proceed with that.
what kind of security?
That will arise on the next record. If additional surety will
You take instructions on that record. Because at no cost we want the public to public money or public to suffer, irrespective of what we decide. Phone it.
Yes, my lord. I know the challenge that I'm facing. I'm completely at my lord's behest. In fact, the decision to come in review was not to offend this honorable court.
No, that's
Yes.
nothing to.
My lord, it
It's
was
your
only
discretion.
a twofold reasoning.
Hmm.
In fact, a brave decision, I would say, to apprise my lord about certain developments in the matter. In fact, in pursuance to the passing of the impugned judgment and order,
Hmm.
certain facts have come into light, my lord. Most interestingly, my lord, the same respondent through his counsel who had agitated regarding the existence of the petitioner had in fact filed a caveat back in the day anticipating actions from the said petitioner.
Who?
The respondent number 7, Mr. Saurav Nath, Mr. Saurav Nath, who claims to be the biological son, who claims to be the adopted son of the deceased individual in whose relation the writ was since moved. He had, through his counsel, filed a caveat before the learned trial court
Regarding what? Trial court.
in anticipation of actions from this particular petitioner, who is
Rega-
now being
regarding what kind of action? Which court?
my lord may kindly see my pleading. I pleaded the same at para number 14, page number 26 of my review petition.
Yes.
Para number 14.
Yes.
My lord has it.
Hmm.
14. That on 10th April 23, this is after the passing of the impugned judgment, the review petitioners, while going to the judicial records being maintained by the Honorable so-and-so, came to know that a caveat has been filed by Saurav Nath, respondent number 7, against Biolin Kharbi, writ petitioner, in respect of a landed property as detailed given below. So-and-so. And after coming to know the said facts, the review petitioners had immediately applied for certified copies on 11th April and obtained the same on 11th April itself of both the caveat and the register, wherein the said caveat was registered and detailed. That caveat was numbered as so-and-so. This discovery of new facts and documents have taken place after passing of the impugned order dated so-and-so by your lordship. That on inspection of the judicial records by the review petitioners in the office of the Honorable Munsif number 1, Kamrup, at Guwahati on 10th April, it came to their knowledge that a petition has been filed by Mr. Firoz Khan, advocate, on behalf of respondent number 7, as his learned counsel against Biolin Kharbi, making it clear that he has knowledge regarding the existence of Biolin Kharbi As such, this petition has been filed. My lord, these are facts and these are documents that I was not in a position to bring before my lord's attention. This is the discovery of the new facts, basis which we are now trying to establish a case in review. And secondly, my lord, as an officer of the court, the review petitioner is an officer of the court, having 10 plus years in practice. We missed filing an affidavit for the assistance of this court. To put the facts in perspective for my lord's consideration, we failed.
So how do you deal with the CBI's report
Yes, my lord, I'm coming to that.
or CID's report that there is no person in the name of Violin Kirby?
My lord, the investigation is still pending. That is the reason my only small prayer before my lord.
What about the number of opportunities granted to you to have the petitioner appear in person? If you are in touch with the petitioner, number of opportunities given, you said affirmatively that the controversy would be resolved by appearance of the petitioner. We said okay, but then suddenly the petitioner went missing. Suddenly you did not have touch with the petitioner, and you said that it was a brief which was handed over to you. We see that the records, everything you had signed, put your signature in the affidavit, not in one occasion, number of occasions. There are letters, RTIs, made in the name of the petitioner. Where has the petitioner gone? Is this a substantial point? Somebody files a caveat against your client.
I understand.
Somebody's done something, and that would be taken into consideration to review a decision.
Please, my lord. I find myself in tough spot. The only small opening which I feel, which I want to establish for my lord's consideration is this. There are certain orders wherein I will show to my lord that I have been consistent with my stance. And those are orders that I wanted to read just for my satisfaction.
Yes.
Please, my lord.
You know your limitation in a review petition.
Yes, my lord.
What are your limitations?
The discovery of new facts
That you have already
highlighted.
pleaded. What else?
And my lord, the scope has since been enlarged now by the Honorable Supreme Court in Madhusudan Reddy.
Hmm.
My lord is already aware of it. For the convenience of the court.
Scope has not been enlarged.
So it has been reiterated.
Scope has not been enlarged. Scope has been reduced.
I know, but my lord, it has been reiterated. I'm on a very,
This is
very
the judgment
small-
by Justice Hima Kohli, isn't it?
Please, please. My lord
So
is already,
yes.
already aware. The only small opening which I feel that I should bring to my lord's attention is the consistency vis-a-vis the review petitioners and the case that was trying to be established by the other side, as in the person alleging regarding the non-existence. My lord, the Advocates Club, one Mr. Nazbul Haq, who is the Advocates Club.
Mr.
of-
Das, you are Mr. Das, isn't
Yes,
aren't
yes,
you?
please.
The review or role is very, very limited. You have to make it a prima facie case. A case of error apparent on the face of it. Discovery of new facts will not go to the respect. This fact is not at all substantial or relevant. Somebody filing a caveat in a trial court against a person who is not existing. That is our finding, non-existing.
Please, ma'am.
Now, on the basis of that, we have taken certain actions against the council. We have not taken direct action. We have referred the matter. Cost, of course, has been imposed because of the conduct, and not against your client. There's whoever has signed the wakalatnama. There are two, I think, advocates,
The review petitioner one is the senior and
whoever is there.
petitioner.
We are not
two.
against anybody personally.
Yes.
Whoever has signed the wakalatnama, they are been penalized because it appears from the record that there was no person existing. 6 years the matter was going on in this court.
The matter is very serious, and I completely bow down to the observations in the
Read court, after all, this
on a
is
very, very small aspect, my lord.
Yes.
I just want to show to this honorable court that even speaking from limited experience, being in Delhi, my lord, I see this situation all the time that my fraternity brothers send me briefs to Delhi to pursue matters before the honorable Supreme Court. And even with good intention, sometimes I don't get the opportunity to verify the existence or the non-existence of a symptom.
You're not required. Here, once you sign in presence of the petitioner, not once, number of times, and you are unable, you're making a statement that you don't have touch with the clients. And on the other hand, there is a statement made by an agency after investigation that no such person exists. Then what do? And you are insisting on the petition. Do you know who are the respondents here? Who are the respondents? Have you looked
a very serious allegation. I do follow.
Have you looked in the purpose of
Please.
filing this petition?
The allegations are very
22 or something respondents, including an advocate who is presently a judge. Why was that done? What was the intention?
I just wanted to highlight the limited.
Mr.
role-
Das,
Yes.
you do not know the purpose of filing the petition. You have been briefed in a manner. You're before the court. We are hearing you.
Yeah, I'm so obliged.
If you
sorry.
see the petition, it contains the actual meaning.
In fact,
Things are shocking,
certain-
horrifying.
in fact, certain
We have taken a very, very lenient view.
in fact, certain questions have fallen from me as well during the course of the briefing.
I had to be filed for deletion of a name. Is that done normally in a writ petition? Person come to be implemented because if there is anything against them, they want to say, person came to this court, they delete my name. Not one. Many of them has not come. Have you seen the array of parties in the writ petition?
Yes.
Come to the writ petition. See who are the parties. Is this how you pursue a writ remedy? Equitable court? Where is the writ petition?
That is the only, yes, it's at page number, the memo party that is at page number 61, 62.
Come to the memo parties.
Yeah, 60,
How many petitioners, respondents are there?
26, my lord.
26.
Yes.
See who are the parties?
Yes, ma'am.
State of Assam, Chief Secretary, Home Commissioner, Police Commissioner, Officer in Charge, Dispur, Officer in Charge, Hatigao, Biran Bora, by name, okay, no problem. Javed Ali, so Niraja Bora, Mukhtar Ali, Sam Bukaria, Mujika, Govind Sharma, somebody, then Poonam Yadav, then see 14,
14 is damaging. And my lord has been
Then-
free to
17,
stop the
Palang,
that response.
so and so personnel department, Meghalaya party, one MLA, 20. What is the significance? What is the relevance? Has it been stated anywhere in the petition? Do you know how this petition has been misused outside the court to the extent? You're not aware of those.
It's very unfortunate, my lord. The
Withdraw this.
allegations are very, very serious.
Withdraw this.
On a very limited aspect.
Withdraw this. Withdraw this. Not withdraw it. You have come. We have heard you.
I'm so obliged. I'm so obliged, my lord. I just wanted to impress my lord on a very limited aspect that vis-a-vis the consistency in my stand, that one legal fraternity brother comes to me for me to pursue a matter. My stand has been,
You should not have signed the wakalatnama.
that was the error. My lord has got me. That
And
is my error.
That this is not a new case. That 16 the matter was filed, 16 we adjudicate. 16 to 23. And it's not one time. The affidavits were filed. If you see the writ petition, there are RTI applications in the name of the petitioner. If the petitioner is existing, it's a very simple thing. Produce the petitioner, that's all.
In fact, my lord, when
Now also you produce the
when I wanted
petitioner.
to file a rejoined,
Now you file you come to the court with the petitioner. We exonerate everything.
this is the difficulty.
We recall our order.
That I have also been taken for a ride as the review petitioner number 1, at the instance of a brother colleague. I have been taken in for a ride. Hence,
Mr. Das, before you make the statement, you know who is your client. Then you make the statement. Will not say anything more than that. Third, and Das counsel for the applicant who by means of this application has prayed for review of the order dated 23/3/2023 passed in WPC 5139 of 2016. Yes, what is the limitation for filing a review?
we were within time.
Hmm?
We were within time.
Filed on 8th of May. Order is of March.
It was filed on 12th of April as per my
Hmm?
Was filed within limitation on 12th of April.
No. It was filed on,
There might be certain
it
objections.
was filed on 8th of May.
There were certain office objections which were eventually cleared.
There is no objection, no defect. Yeah, of the order dated 23/3/2023 asked in WPC 5139 of 2016 by the said order, while the writ petition has been dismissed, the matter was referred to the Bar Council for appropriate steps against the council on record involved, and cost was also imposed. This review has been filed by one of the council who was representing the so-called petitioner. This court, after hearing the parties and taking into account the various reports placed on record, including the report of the investigation agency that no person in the name of the writ petitioner was existing, had given a number of opportunities to the present applicant, who was the counsel, to have the petitioner appear in person before this court, which was initially agreed, which was readily agreed to be done. However, in the subsequent dates, the stand of the council had changed by submitting that the writ petitioner could not be contacted. No, this court had recorded various reasons regarding the steps taken by the same council, regarding the steps taken on behalf of the so-called writ petitioner in filing applications under the Right to Information Act, and the writ proceeding had also continued for about 6 years, and on 6 years, under those circumstances, and taking into account the material before this court, the order has been passed. Thus, the learned counsel has submitted that after passing of the order, the applicant could come to know about a caveat being lodged in the trial court against the writ petitioner, and from that he has submitted that inference can be drawn that the petitioner, writ petitioner was existing. The aforesaid submission is not relevant, as the same relates to a caveat in the trial court from which only an inference can be drawn. In any case, the role of a review court is a limited one, wherein powers of review can be exercised only under extraordinary circumstances, which does not appear to be existing in the instant case. Under the aforesaid, the learned counsel has placed reliance upon the case of S. Madhusudan Reddy versus this court, the effort, the Honorable Supreme Court in the state case had endorsed the earlier view of the Honorable Supreme Court in the case of wherein the following principles have been laid down. In the opinion of this court, the aforesaid decision, rather than coming to the aid of the applicant, would be against the applicant, as the limited role of a review court has been once again emphasized by the Honorable Supreme Court. Under the aforesaid facts and circumstances, this court is of the opinion that no case for review has been made out, and accordingly, the same is just.